Got it. Okay. Welcome back to the ongoing public hearings of the Environment and Transportation Committee. I'm your chair, Kumar Barve. I'm joined by the vice chair, Dana Stein, and the happy gang of environmental transportation committee members. And so we are going to be going through our public hearings, I believe, in numerical order. And so the first bill is going to be House Bill 331, Delegates Boatler and Buckle. Next, House Bill 343, Delegates Novotny and Ernst. House Bill 358, Delegate Charles. House Bill 367, Delegate Williams. House Bill 381, Delegate Solomon. House Bill 382, Delegate Otto. And finally, House Bill 392, Delegate Stewart. And so with that, we welcome Delegate Boatler to the Environment and Transportation Committee. You have 4 minutes. The timer will cycle 2 and 2. So take it away, Joe Boatler.
Thank you. Thank you, Chairman Barve and members of the Environmental and Transportation Committee. For the record, I am Delegate Joe Boatler, and I'm here today to discuss House Bill 331, Local Government Regulation of Amateur Radio Station Structures. This is the same bill that I introduced last year as House Bill 663. There are no changes. This bill passed out of this committee and passed on the House floor with no opposition. California and Virginia have also passed this same piece of legislation. This bill establishes certain requirements that apply to a county or municipal ordinance regulating amateur radio station antenna structures, which are often unnecessarily regulated with zoning laws. As a reminder of what I shared last year, I want to remind you that an amateur radio operator is federally licensed and must follow Part 97 of the FCC rules, Amateur Radio Services Rules. They use their own infrastructure. When called upon, amateurs use their own equipment such as radios, power supplies, antenna, and the like to set up a communication center inside or outside and interface with event coordinators to position radio operators at predetermined locations. They provide in-situational awareness, looking for potential weather or other events that may require emergency communications to be used when requested. And finally, they work with the local, the state, and federal agencies to coordinate efforts and assist when called upon. Amateur radio operators have proven the critical nature of the work in emergencies time and time again, whether it's a weather emergency like a tornado or a hurricane, or a disastrous event like 9/11 or the Boston Marathon bombing. Just to give you a couple examples, September 9th, 2001, 9/11, New York City Twin Towers. September 19th, 2003, you had the Hurricane Isabel. August 23rd, 2011, the earthquake that we had here in Maryland and on the East Coast. April 15th, 2013, the Boston Marathon bombing. And as we've seen recently, there have been tornadoes in the Midwest and flooding in some of the southern states, and they came into play at that time. Given the rules that they are subject to and the assistance they provide at no expense to government agencies, Maryland should join with other states in protecting their infrastructure from being overregulated. With that, I thank you for your consideration of this bill and urge a favorable report.
Well, thank you very much, Delegate. And we have 2 people who are signed up one person who signed up to testify, and that is Tom Henry, who is hopefully with us somewhere in the House. Tom,
right here, sir.
Thank you. Welcome to the committee. You have 2 minutes, sir.
Before I begin, if it'd be okay, we've done this. I think I was told I would be here for answering questions, but I can certainly testify based on the written that I sent. I did sign up for oral, but that's up to you, sir.
Yeah, no, I mean, if you just want to be here to answer questions, that's fine also, but
That's fine. Yeah, because I provided a written. Basically, it was the same as last year. I would note I had one edit that I had failed to about submitting a copy of an article. I did that last year, didn't do it this year. So the testimony last year is identical. It's up to the committee's discretion. It doesn't matter to me. It's fine.
Okay, well, we do
It's been
have
heard twice now, so
we have a couple of questions. The first
that'll
one
be fine.
So, I'm sorry. We have a couple of questions. The first one goes to Delegate Ruth.
Thank you, Mr. Chair, and thank you, Delegate Boatler, for bringing this bill. And I think I may have mentioned this before, but my dad was an amateur radio operator, and I still remember his call sign W3 WCP. So I just wanted to ask. You mentioned that they're licensed, and I was wondering, is there still a test required to get a license?
Is that for me? Is that for delegate?
Whoever can answer.
The answer is yes. The answer is yes. At the most, they've changed the levels over the years, but there's like 3 levels. When I was getting it, there was the technician. That's a set of 30 questions. Then the general, which I am now, there was an additional set based on an advanced set of questions. And then the final one called the extra, which is really advanced. But yes, it still does exist. Yes.
So it's safe to say these people know what they're doing when they're putting up an antenna.
Yes. And because the word amateur, as you well know, Delegate, it doesn't indicate a lack of skill. It just means we're not allowed to take money for what we do.
Great.
And that's so-called the amateur status.
Thank you so much.
Sure.
Okay, the next question goes to Delegate Jacobs. Jay?
Thank you, Mr. Chairman. Seems like we're having network problems today.
A little bit.
I was on a call this morning and it was really spotty. So I hope it improves before we get into too many bill hearings. But I wanted to go over again with the sponsor of the bill. Last year's bill, 663, I think it was, it passed the House unanimously and got over in the Senate. And what happened there?
Well, I think what happened is it got caught up in there and whatever there were some issues that were going back and forth between the House and the Senate, and it just died along with a number of other bills.
So in other words, it got over to EHE and just never got a hearing or anything?
No, I did have a hearing. It just never was pulled up on the voting.
Okay. Thank you very much.
All right, next question goes to nobody. Nobody else has their hand up. So, okay, thank you very much. That ends the public hearing on House Bill 331. Let's proceed to.
Thank you, Mr. Chairman.
Absolutely.
Thank you very much.
Have a great day.
You too.
Okay, thank you. House Bill 343, Delegate Novotny. Welcome to the Environment and Transportation Committee.
Thank you so much, Chairman Barve and members of the committee. For the record, my name is Delegate Reed Novotny. I represent parts of Howard and Carroll County. I think you'll see that this bill is fairly simple and straightforward, and the intent of this bill is to create equity between the landlords and the tenants with respect to deposits, security deposits and the like. Currently, the law sets a lower limit of interest that landlords must return to the tenant regardless of what we currently have in the markets, which is 1.5 specifically within the law. The specific language states within 45 days after the end of a tenancy, the landlord shall return the security deposit to the tenant together with the simple interest that is accrued at the daily U.S. Treasury yield curve rate for 1 year as of the first business day of each year. What I'm recommending is removing that 1.5% year, whichever is greater, less any damages rightfully withheld. So that's the paragraph of the law we're looking to change. I do not believe the original intent of the legislature was to have the 1.5% as a floor. Was ever thought that landlords would be making up the difference to their tenants in this way. But in a time of very low interest rates, I was told that this is punitive to landlords from the person who brought it to me as a concern. To bring this into equity between the landlords and the tenants, we should allow the rates to be dictated based on the rates that are available in the markets. I do appreciate your time today, and I would urge a favorable report on this proposed law. Thank you so much, Chairman.
Thank you. And it looks like everybody who has signed up on this bill has signed up only with written testimony, both the opponents and the supporters. So if there are any questions for the sponsor, Delegate Linda Foley has a question. Delegate Foley, proceed.
Thank you, Mr. Chair. Delegate Novotny, do you know what the current U.S. Treasury yield, what the current U.S. Treasury is on the yield curve? Do you know what that is at the current?
So I thought I looked up this morning, which was 0.11 on an average bank account, like 0.11. I'm not sure if you were seeing the same information. And I was trying to explain, sorry to be less clear, a few constituents had brought this to my attention, and they were making up the difference because it was under that 1.5% limit. But I don't know if you've seen something different.
No, I was asking because I didn't know. And then a follow-up question is, generally speaking, or maybe you can speak to this, maybe you can't, but generally speaking, I mean, I know when it comes to rent, it's usually a security deposit of a month. What is it for example, in a mobile home park?
Great question again, Delegate. I believe it's similar, and the intent is not to change any of the language around what is currently in the contracts and what you're seeing. It's just to allow the free market or the market to dictate that annual interest rate to make sure we're not denying basically the tenants themselves. They should be getting interest on their money, just like the landlord shouldn't be digging into their own profits to pay back something that's not available to them.
Right. So actually what we're talking about here in terms of the floor that you're removing is 1/12 of 1.5%, correct?
Yes, Delegate.
Generally speaking, correct?
Yes, Delegate.
Okay, thank you.
Thank you.
Okay, next question goes to Delegate Ruth.
Thank you. Thank you, Mr. Chair. Delegate, this may be a stupid question because I'm not a financial expert, but so if the current interest rates are low, but let's say somebody's lived in their apartment for 10 years and the interest rates were high during that 10 years, how would this be calculated then?
So the way I understand it, and I again I am a cybersecurity expert in my own right, but not a financial advisor. So what it is calculated in the current law is that it is recalculated every year, and this is the floor. So they're looking every year. So it's not like if you started renting in the 1980s when things were totally crazy with the interest rates, you would have that high amount. It is calculated year by year, but you still have that in what I'm trying to change. You have that floor that could be above what you can get in a typical bank account. So great question though, ma'am.
Thank you. So, sorry, just following up. So if the rates are low now, so would it be, if this bill were to go into effect, would the earlier years where the rates are high still be calculated at a higher rate?
Yes, ma'am. This should not go in previously. It's this going forward, and there's the typical date that it will become law in the future.
Thank you.
Next question goes to Delegate Stewart.
Thank you, Mr. Chairman, and thank you, Delegate, for joining us this afternoon. I just took a quick look at the floor testimony. It looks like we got some unfavorable testimony from the Office of the Attorney General. I don't know if you had a chance to look at that. I just skimmed it. It looks like their concern with the bill is that in 2014, there was some sort of compromise that the General Assembly crafted to try to make sure that there was a floor, but also that mostly we kept with what the prevailing market conditions were. I think, and apparently the idea there was to make sure that not all of the financial risk is, as they say, hoisted on the tenant with respect to the opportunity cost of putting in a security deposit. And what they mean there is, as you probably know, the S&P 500 performed at 27% in 2021, for example. So by forcing a tenant to put in a security deposit of, say, up to the maximum legal limit, which I think is either 2 or 3 months in Maryland, is potentially a huge opportunity cost hit for the tenant. Now, obviously, we understand why landlords take security deposits, but do you have any response to that sort of opportunity cost concern from the OAG?
So I think it's in our best interest of all Marylanders actually to work toward, in my opinion, home ownership, right? So I actually am a landlord. I encourage all of the tenants who have ever rented from me to actually move out and try to buy their own houses and become landlords, because that's how our society since George Washington has been making money. I think the opportunity cost, I totally agree with you in the sense that it needs to be a shared risk. This specific one, as it's drafted right now, is really just about a bank account. It's not necessarily about other investments, because those other investments, are not FDIC insured. So really, if we're going to put something into some type of S&P or some type of some other investment, that money could go to zero, which obviously this rent or this deposit would never go to zero. It always accrues interest. So really, I think it's a balance that I'm looking for. But I do really appreciate that question. It's a great question.
Yeah, I appreciate the answer. And I guess just to go back to the first thing you said, are you saying that part of your intent with the bill is to try to push renters into home ownership by making it slightly more costly to be a renter?
Not at all. I just think that as a non-financial person, I think home ownership is great. That's all.
Okay. All right. Thank you.
Any further questions? I'll just say as an editorial comment, I've been here for 30 years, and I remember being on Economic Matters in the early 90s, where bills like this were often put in, and frequently the bills would favor landlords, and typically the landlords would come in and testify against the bill because they said, sometimes the interest rate will go up, sometimes it will go down. We just want something simple. I see they're supporting it this time, but in any case, just a little bit of color for the proceedings. So there are no further questions, and I believe nobody else wishes to testify. So that ends the public hearing on House Bill 343. Thank you, Delegate Novotny.
Thank you so much.
House Bill 358, Delegate Charles.
Thank you, sir. Thank you, sir. Good afternoon, Chair Barve, Vice Chairman Stein, and the honorable members of Environment and Transportation Committee. For the record, my name is Delegate Nick Charles, and I am here in support of House Bill 358, which is the Maryland Condominium Act amendments to the Declaration, Interests and Common Elements. This bill proposes that the Maryland amend Section 11-103 of its real property statute. The proposed modification will permit the boards and council of unit owners to make amendments to their community's Declaration of Covenants with a supermajority of 60% of unit owners, as opposed to the current requirement that all 100% of unit owners or mortgagees must support any proposed amendment or change in a community's declaration. This current requirement under the real property statute of requiring 100% of its unit owners and or mortgagees to support any change is exhaustive. It presents an insurmountable barrier to enact any type of reasonable change, particularly if and when there is lopsided benefits to maintaining the status quo for some of the unit owners at the expense of others, such as in the definition of common elements and how a community's dues are calculated and enforced. In most, if not all communities, it is impossible for 100% of unit owners and mortgagees to agree on most things. Yet change and evolution are inevitable and healthy for any community to thrive. Indeed, in 2017, Section 11-104 of the real property statute was similarly amended, and for those same reasons to make it easier for communities to amend their governing documents, such as their bylaws. It is imperative that a similar modification to Section 11-103, Section C1I of the real property statute be approved and applied so that the amendments to the community's Declaration of Covenants can be approved with a supermajority of 60% of votes of unit owners and mortgagees. This change will undoubtedly ensure the communities continue to thrive without being impeded by unrealistic voting thresholds that are impossible to meet. I urge for a favorable vote on this particular bill, and I'd like to thank you for taking the time to hear me on this bill. And I don't have anybody come to testify in support or against. I may have a person against, and I think it's the bankers and we're working on coming to a resolution to the bill.
Okay. By the way, how do I sound now? I changed my microphone. Do I sound any better? Ben Jabin is shaking his head. So
it's the same mic you were using before. It hasn't switched yet.
Oh, all right. Okay.
I can come help you figure it out in a sec while the hearings are going.
Okay, sure. Okay, so let's go to, well, any questions for the sponsor of the bill? I don't see any questions. So we will go to the only person who signed up in opposition to testify, and that's Bob Benton with the Maryland Building Industry Association. Bob, you've got 2 minutes.
Yes, thank you very much, Mr. Chairman, and Robert Enton. I'm testifying today on behalf of the Maryland Building Industry Association, as well as the Maryland Bankers Association. If I didn't indicate that on the sign up, I apologize. We are opposed to this bill. I did have a good conversation with the sponsor last week about it. We look forward to sitting down with him. You know, the problem with the bill as written is that now you can divest a condominium unit owner of their ownership interest in the common elements based upon a 60% vote. And when you transfer that in so you could have 40% of the owners who are somehow opposed because they feel like they're being divested of an ownership interest. And when they buy the property, they buy it and they're buying a condo unit or a townhouse with the, because they're going to have the right to use and an ownership interest in the common elements. Likewise, more so for the mortgage holders on those units, the law has always said you need the consent of the mortgage holders. Now, I don't know that in my conversation with the sponsor, he pointed to an example where the utility bills and or the water charges are split based on people's ownership of the units evenly. So if I have a 4-bedroom townhouse, I'm paying the same thing for water perhaps as a 1-bedroom condo unit. And maybe that's something that could be regulated, but the notion that you can divest a mortgage lender in effect of, because they have an ownership interest, just like the owner of the condo unit in the common elements. That's what they made their mortgage loan based upon. And right now you need their consent. No one's ever come to me, and I'll wrap up, Mr. Chairman, in all the years that I've had to represent the Bankers Association, and the builders have indicated this is a problem. So we look forward to working with the sponsor, getting more information, and seeing if there's something that can be worked out to address his concerns. Thank you.
Okay, any questions for the opponent to the bill? Don't see any, so it looks like that's the end of the public hearing for House Bill 358. Thank you, Delegate Charles. Let's proceed to House Bill 367, Delegate Williams. Are you with us?
Yes, I'm here. Mr. Chairman.
You've got, welcome to the Environment and Transportation Committee. You have 4 minutes. The timer will go 2 and 2. That's how you'll know what your time limit is.
Okay, thank you. Good afternoon, Chair Barve, Vice Chair Stein, and members of the House Environment and Transportation Committee. I'm Delegate Nicole Williams of District 22, and I will be testifying today in favor of House Bill 367, also known as the Landlord and Tenant Repossession for Failure to Pay Rent Rental Assistance Programs. This emergency bill would require landlords to send tenants information about the programs available for emergency rental assistance funds, for landlords to seek out funds from one of the rental assistance programs if a tenant is experiencing a financial hardship related to the COVID-19 pandemic before filing to evict, and just to provide any documentation requested if the tenant seeks funds from a rental assistance program prior to the landlord commencing any type of eviction action against the tenant. This bill will expire when all of the Federal CARES Act money or the American Rescue Plan money expires, or on June 30th, 2023, whichever comes first. So it's not indefinite. Difficulties and paying rent because of the pandemic are found to be more prevalent, unfortunately, in communities of color, with 28% of Black renters, 20% of Asian renters, and 18% of Latino renters reported being behind because of pandemic losses. And several property managers throughout our state have been really great about working with tenants during this pandemic, but some have also continued to press forward with filing for evictions, even though that they know the tenant has applied for rental assistance and currently has an application pending. The emotional and psychological effects that this has on tenants who are actually trying to do the right thing causes undue stress on the tenant as well as their family and loved ones. This bill places a small stay on the process at the beginning instead of the end of the eviction process, which prevents the tenant from having a court filing that will show up on their credit and that will show up in their records, which may down the road harm that individual's persons from being able to obtain housing in the future, credit, or even employment. You may hear some criticism that this bill will dramatically delay the process for landlords, or, about the backlog of cases and the need to file for eviction as quickly as possible to preserve their interests. However, again, this bill expires in 2023. And so we feel as though this will bring at least a temporary peace of mind to the tenants who are in these unfortunate circumstances because of the pending pandemic. And if the tenant chooses not to seek the assistance or work with their landlord or is ineligible for relief, then the landlord can proceed forward with the eviction. But we feel establishing this step in between a failure to pay rent will be crucial in keeping people in their homes during this continued public health emergency. And for these reasons, I urge the committee to give a favorable report to House Bill 367.
Thank you very much. We'll go through all the proponents and then we'll entertain questions for them. Next up, Zafar Shah. Zafar, welcome back to the committee. You have 2 minutes.
Thank you, Chairman Barve and Vice Chair Stein and members of the committee. My name is Zafar Shah. I'm an attorney in the Human Right to Housing program at the Public Justice Center. We provide legal assistance and representation over 600 renters a year. We worked closely with the Baltimore City District Court and with multiple stakeholders, including landlords, the sheriff, and the city of Baltimore, to work on what was eventually called the Pandemic Rent Court Program, to try and put interventions into the pre-trial phase of these failure to pay rent actions during the pandemic over 2021. And in some instances that was a successful effort. In many other cases, it really led to inconsistencies and the often refrain, which was, I'm sorry that to, Mr. or Mrs. Renter, but we can't force landlords to use rental assistance, even if you're eligible, even if it's available, before we enter a judgment here for eviction. Public Justice Center conducted a survey of 30 attorneys throughout the state of Maryland that do pro bono housing legal services. And it's not a very large sample, but the sample does show us that about 30% of those attorneys said that when their client was in a court process for failure to pay rent and had already applied for rental assistance and the landlord had not participated yet, those cases still went to judgment. About another 30% said that judges did the right thing, in our opinion, which was to stay those cases, even above the landlord's objection. But what those numbers tell us is that it's really not very consistent to expect that judges will delay these cases to allow rental assistance to work when the process has already started. So this bill, which Public Justice Center supports and asks for your favorable report on, would create the pre-filing mechanism so that we're not in this predicament while emergency rental assistance is available, that tenants are waiting for the assistance, waiting for their landlords to act while the gears of eviction are already in place. So we seek your favorable report on this bill. Thank you.
Okay, thank you very much, Zafar. Next up, Carissa Hatfield. Carissa, welcome back to the committee.
I don't believe Carissa has arrived at the call yet.
Okay, then let's go to Maryland Legal Aid, and I'm not sure who's here for them, so please announce yourself.
Hi, thanks, Chairman. My name's Harry Montz. I'm a staff attorney at Maryland Legal Aid. So Maryland Legal Aid supports this bill, and we represent low-income people and low-income tenants throughout the state of Maryland. We have seen a significant amount of tenants be evicted while going through the rental assistance process. It's because they have cases filed that don't get dismissed. Even those that are, I even had a tenant recently who went through the entire process, got all the paperwork signed. The landlord even signed paperwork saying they would dismiss all the cases, but they ended up not doing it for whatever reason. Tenant didn't go to court and they were evicted. And the toll eviction takes on people can't be overstated. If they get evicted, all their property is generally considered abandoned. They have to find a new place to live, and it's really hard to get, almost impossible to get them back into that property. So this bill is just going to let people be able to get that money without, without having to be afraid of eviction, without having this devastating timer on their back, threatening to kick them out of their homes. And we think it would be a tremendous benefit for tenants throughout the state, and we would encourage your favorable report. Thanks very much.
Okay, thank you very much. Next, let's turn to Corey Warren. Corey, welcome to the Environment and Transportation Committee. You have 2 minutes.
Great. Thank you for allowing me to testify on this bill. I'm a staff attorney with Disability Rights Maryland. We are the congressionally mandated protection and advocacy organization for those with disabilities in the state of Maryland. We are urging a favorable report on HB 367. I'm not going to repeat too much of what my colleagues have stated already on this call, but overwhelmingly, we have seen issues with landlords moving forward with evictions before tenants can even participate in the rental assistance program. We've seen that in our practice. We've heard that from the community. And just from the disability community's perspective, the disability community has been overwhelmingly impacted by COVID-19. According to the Bureau of Labor Statistics, 1 in 5 people with disabilities lost their employment in 2020 as compared to 1 in 7 for the average American. Meaning that they are facing higher rates of eviction filings than any other community and are having a harder time getting back into employment. So the rental assistance program is really a lifeline for the disability community right now to stay in independent housing and not being forced into nursing homes, institutions, or state hospitals. By allowing a delay for them to participate in the rental assistance program and giving them the information on how to participate is absolutely necessary because it prevents, the landlord from speed rolling somebody into an eviction before they can actually get the finances to the landlord. This is also a public health concern for those with disabilities, especially autoimmune disorders. Facing eviction and homelessness means that they are at higher risk of being infected with COVID-19. People with disabilities, especially, as I said, with those with autoimmune disorders, are much more likely to die or face serious hospitalization from COVID-19. So
if you're able to wrap up your testimony, the committee will appreciate that.
All right, I'll end on that point.
Okay, thank you very much. Next, let's go to Mike Sanderson with MACO. Mike, welcome.
Thank you very much, Mr. Chair and committee members. I'm Michael Sanderson with the Maryland Association of Counties, here in support of the bill, and we thank the sponsor for introducing it among what looks like a variety of policy options that will be before the General Assembly this year. County governments are not before this committee all the time on landlord-tenant stuff, so this isn't exactly familiar territory for us. So I want to speak, rather than speak to the bill, which you've already heard about, I'll speak to our role here. County governments are central actors in these relief programs. A lot of the federal funds for tenant relief have come through county governments, and that's compounded by the state devolving a good deal of its funding through county governments. So we're in the middle of this, and I think county governments recognize we've got a societal stake in making these programs work as best they can. It will be a policy failure every time someone who is in the category we want to serve with the aid program who misses the opportunity to receive that benefit. I recognize that, you know, where we are is the federal and state basically moratoria have expired and have been replaced by aid programs, which is necessarily less effective. Having something you need to apply for and receive and go through a process is less effective than saying you just can't evict or you have to go through special processes to evict. So there's inherently holes in the boat. We want to minimize them where we can. I know this committee needs to strike a balance on the multiple players here, and I think the counties recognize that. I think the bill that's before you is a good one to consider as you try and strike that balance, and we're here in support.
Okay, before I recognize Carissa Hatfield, who I understand is in the chat room, I must say, we never had an absolute moratorium. It was an affirmative defense. So it is not that we ever had an absolute moratorium. Okay, anyway, next, the committee welcomes Carissa Hatfield to testify. Carissa, you have 2 minutes.
Thank you very much, Chairman Barve and members of the committee. As stated, my name is Carissa Hatfield, and I am a housing attorney with the Homeless Persons Representation Project in Baltimore, Maryland, which serves tenants in Baltimore City, Prince George's, and Montgomery counties. I want to reiterate and lift up much of what has already been said and try not to take up too much of the committee's time. The only thing I will add is that this bill is essential to tenants at this point in time. While there is some belief that we're out of the woods or we're close to out of the woods, the truth is that for many tenants, this is only beginning. There are tenants during Omicron who are losing their employment now and hadn't faced previous employment crises prior and are going to be in need of rental assistance that comes under the CARES Act. In previous times, we've also seen many tenants who, instead of getting rental assistance in time, have had to try to scramble to find money from family or friends in order to make sure that they stayed in their homes. Rental assistance programs are doing the best they can, but they are just trying to plug the holes as quickly as possible to prevent people from being evicted. That is why HPRP is in support of House Bill 367, and we urge a favorable report. Thank you.
Thank you. Are there any questions for the sponsor or any of the witnesses? If not, I have a question for Zafar Shah. Zafar, so tell me functionally how this would work if this law went into effect. Let's say that I'm a tenant and I'm not able to pay the rent, but who has to apply for rental assistance? And if this law passes, how would it functionally work from the point of view of the tenant?
I think that the critical piece is that this bill would require a landlord, before they file their failure to pay rent case, to have sent some kind of writing or notice to the tenant to let them know that action is foreseeable, and please provide information about your eligibility for rental assistance. Once the landlord's apprised of that eligibility or of a pending application, now they're on notice to attempt that resolution of the rental debt before they file. That window of opportunity to resolve it before filing of a failure to pay rent case is 45 days. 45 days is a number that has some precedent. Philadelphia adopted that number at its local level. Washington, D.C. and Virginia have taken up similar procedural mechanisms that are proposed here. But one thing that is not stated in the bill is how this mechanism would dovetail with the newly enacted 10-day pre-filing notice that was passed by the legislature last year in House Bill 18 and became effective October 1st of 2021. That notice already provides some information about rental assistance, but there isn't that subsequent requirement for the landlord to take action on their own.
Okay, let's look at it from, let's say instead of being the tenant, I'm the landlord and I have a tenant who is behind. What do I have to do to be under this bill? What will I have to do, and how quickly will I have to do it under this bill to allow me to go to court?
So my understanding, and I'm sure that my counterparts in the industry coming up on the opponent panel will have a better synopsis of this. The landlord would be required to make that communication with the tenant, understand whether there is an application, a renter initiated application, or whether based on their eligibility, that there should be a landlord effort made, whether participating in the renter's application or creating a landlord initiated application. And they have to pursue that resolution with the emergency rental assistance program for 45 days. And it might be that there's ineligibility, that there's a lack of funds, what have you. But after 45 days, if there's not an outcome on a good faith application because the local program hasn't completed that process and distributed funds, the landlord can then go to the district court and file their complaint.
Okay. Any other, Delegate Holmes has a question, I see.
Thank you, Mr. Chair. Thanks, Mr. Shaw, for being here today. So I'm interested in understanding the total time frame that is going to be required in terms of the landlord-tenant process for filing the eviction process. So we've already added the 10 days. And so this would add 45 days from what point to what point? Hello?
Zuffer?
Yeah, sorry, my mute button is sticky here. So my understanding is that there is a period of inquiry plus 45 days. And I'm defer to Delegate Williams on the specifics of how much time before the 45 days is required by the bill.
Yeah, I mean, the bill envisions that once the tenant basically goes into default as, you know, defined by statute or the lease, then at that point, once the default period begins, that's when the 45 days would begin, is what was envisioned.
And that works with the already required 10 days. Then the 10-day notice has to be a 10-day notice. And now this says that there's a 45-day tacked onto the back of the 10-day or before the 10-day.
I think we're happy to kind of maybe tweak it to make that a little bit clearer with this bill. But I think what was envisioned is taking the 10 days and removing the 10 days and making it just simply 45 days.
Okay. Thanks, Nicole. Delegate Williams.
No problem. Thank you.
Okay, next question goes to Delegate Jalisi.
Thank you, Mr. Chair. So just for my information, I understand the 10-day and the 45 days, but in cases of these funds that are being given out in rental assistance, the agencies are also asking for 90 days after the funding period ends. So let's say that a property owner has a tenant who is behind in rent by, let's say, 90 days. And they do accept and go through this 10-day notice period and then a 45-day period for receiving of those emergency funds to prevent eviction. But they're also being required to agree that after that previous 90-day unpaid rent is paid off by the agency, that they have to agree to not go back to rent court for the future 90 days. Potentially, the problem I see is then the property owner is stuck in the same situation that for 90 days, they're not getting paid and then they're back to square one. My question is, does this bill address that issue? So let's say, let me make it easier. We've given a notice for 10 days. We have tried in for 45 days to get the payment, and the payment is received within those 45 days. Does the landlord still has to agree to the stipulation that after receiving the payment, they can go back to rent code for another future 90 days for which no payment is being made?
Right. I guess I'll take a stab at the question. So this bill is not addressing kind of that 90-day period. It's just simply addressing kind of when the landlord has the ability to start to commence with eviction proceeding, just staying that for 45 days. So in your question, Delegate Jalisi, if they apply, they receive the funds from the local jurisdiction to pay the back rent, and the rent is paid, but then all of a sudden the tenant defaults again, I think that clock would start to tick again under this bill. There is a provision, I think, if there was a previous application, I think it might be on page 4 of the bill.
I think Carissa Hatfield might have an answer to that. Do you, Ms. Hatfield?
I can take a stab at an answer. So if we were in this hypothetical that you've laid out, Delegate Jalisi, and the payment is made, any contractual obligations that occur between the landlord and the fund distributor are a part of that contract. They're not subject underneath of this particular piece of legislation. So that would be a conversation that would need to occur between the landlord and the party that's distributing the funds. It's not affected by this proposed bill at all.
Well, actually it is. Because now what happens is because of the, for example, Baltimore County DSS or Baltimore City is saying you can't file for 90 days. And then after 90 days, if a property owner goes back to rent court for non-payment, so he has to wait or she has to wait 10 days for the notice and another 45 days, right? According to your bill. So now it is 90 plus 10 plus 45 to file a new rent court action.
Respectfully, Delegate, the landlords receive payment for, at this point, the programs are paying anywhere between 12 and 18 months up to rent. And so landlords received a substantial payment.
Back rent, ma'am, not for future rent. They're not paying future rent.
Jay, let her answer the question.
Right, I'm just clarifying the number.
No, let her answer the question.
Sure.
Thank you. Yes, thank you, Chairman Barve. What I was trying to say is that the landlord at that point would have received a payment. At this point, the programs are paying up to 18 months of, back rent, which means the landlord would have received a substantial payment. If the tenant is continuing not to pay, then yes, this process would be triggered again. But the landlord has received payment at that point of a substantial amount, which may help them pay any back bills that they may have. I think this is it's best to create a balance. And while it may be something that we may have to clarify some language or figure some things out, and it sounds like the delegate is willing to do that, in my mind, it does attempt to strike a balance between the landlord's interests and the tenant's interests.
Okay, I'd like to move on to the opponents of the bill, Delegate Jalisi. So let's go to the opponents of the bill, and probably you can put the same questions to them. So the first opponent of the bill to testify is Grayson Wiggins with Multi-Housing Association.
Good afternoon, Mr. Chairman and members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. I just want to address a few things that were just said. One, this committee has heard me say time and time again that evictions are down. They continue to be down. Two, what this bill actually does is it creates an additional notice, or a notice in addition to the 10-day notice of 14 days, and then tacks on the 45-day wait period to what is already a historically delayed court system. So I just want to put this in perspective. One, rent court is closed right now in the state of Maryland. It's going to be closed till at least March 7th. We have jurisdictions in this state where the time between a court filing and a court hearing is more than a year. So in Baltimore City and Prince George's County, for example, on a year-long lease, a tenant could move in, never pay rent, and the lease would end before a hearing took place. Two is, you heard a lot about from the proponents this idea of balance. What this bill does is, as I mentioned, evictions are down precipitously. They've declined since August when the affirmative defense was removed as well. So we know that the system is working, but if you enact this bill, what it does is it requires landlords to agree to contracts for rental assistance, but there's no state contract for rental assistance. So the local governments could put whatever they want to, any provision they want to in that agreement, and landlords would have to agree to it. Finally, what this bill does is it really unintentionally incentivizes tenants to do nothing when they receive a 14-day notice. So if you receive the notice and you don't pay the rent, the landlord then has to apply on your behalf for, again, what could be a contract that includes any number of future provisions. And there's other practical realities. I mean, it's almost, candidly, it feels like we're reading different bills. I mean, there's practical realities because landlords can't always apply either. And Ms. Howard's going to touch on that.
Grayson, your 2 minutes. Yeah, your 2 minutes are up. Let me go on to the next person. I'm sure there'll be questions. Catherine Howard is with us right now. Catherine, welcome to the committee.
Good afternoon, Chairman Barvey and the rest of the committee. I'm Kathy Howard. I am General Counsel for Regional Management, Inc. Regional Management owns and manages affordable housing in Baltimore City and Baltimore County. We have about 5,000 units. You have my written testimony. In there, I talk about and I think it's very important, Grayson just touched on it. No program that we're aware of in the state of Maryland allows the landlord to, on their own, apply for tenant rental assistance. Nor should they, because the landlord essentially does not have the information that the tenant has that is required for these programs to be able to determine the eligibility of the tenant. In Regional's case, we have notified our tenants every single time, the CARES Act, ERAP 1, ERAP 2, to let them know that there is assistance available. We have set up computer operations in our rental offices. We have trained our staff how to help the tenants to get these things together and get them into the program. The landlord does have things that they have to supply to the program once the tenant has applied and is determined to be potentially eligible by the program, such as the lease, the lead certificates, things along those lines. But we cannot apply for the tenant. And that is a terrible flaw in this bill, where it says that the landlord has got to make the application on behalf of the tenant. That is just not, that's just not a way the programs work. I want to make sure that you understand what regional management has experienced. We have had 777 tenants who have actually gotten a rental assistance. However, that only represents 65% of the number of tenants who are delinquent with us.
I'm going to have to ask you to wrap it up here.
Sure, will do. And I'll be happy to take any questions. But I think that it's important for you to note and for you to understand that not all tenants that may or may not be eligible, but who are delinquent, are taking advantage of these programs. And it is not because the landlords haven't let them know. Thank you.
Okay, Bill Castelli is next. Bill, welcome back to the committee. You have 2 minutes.
Thank you, Mr. Chair, members of the committee. Bill Castelli with the Maryland Realtors. And about 30% of our members are engaged in property management of some kind. Our members mostly manage the smaller single family properties. So these might be townhomes, condominiums, single family detached properties. And I will tell you, one of the issues that we're also concerned about is not just the length, the additional length in terms of applying to the programs and waiting to hear back about whether you're accepted, because this would add another 2 months. And we do agree with the concerns about adding an additional 14 days to the 10 days. That period was increased from 5 days to 10 days last year, is the fact that even when you get accepted into a program, we have had instances of property managers and their tenants waiting months before that payment comes through. So if you're a small owner of a property, you may be paying your own mortgage, you may be paying the mortgage on your rental property as well. You could be talking about, 2 months under this bill that you're waiting to hear back on an application and another 4 months before the payment actually starts coming. So if you're 6 months in without payments, you're trying to front both of these. That's a very difficult financial obligation for many small property owners to handle. And I would also mention too that with the market the way it is right now, we've seen from our property managers anywhere from about 3 to 20% of their portfolios being sent into the for sale market, where property owners are taking advantage of a strong sales market. And with these disincentives, I think it makes it very difficult for a lot of these small property owners to want to stay engaged in providing what we think is a very critical element of the rental market, these kind of single family detached properties and single family homes.
Okay, thank you very much. The last witness to testify against is Aaron Bradley. Aaron, welcome back to the committee.
Thank you. Good afternoon, Chair Barve and committee members. I'm Aaron Bradley, representing the Apartment and Office Building Association of Metropolitan Washington. Most of my points have been covered eloquently by Grayson, Kathy, and Bill, so I'll highlight some of the realities specific to the jurisdiction AOBA represents. When courts reopen in March, it's expected to take about 14 months between filing and going to court in Prince George's County and 11 months in Montgomery County. In that regard, an applicant for rental assistance will receive confirmation and payment of funds long before they must ever go to court. So if the goal is to ensure residents have the opportunity to receive rental assistance, pay their delinquent balance, have the case dismissed, and stay in the property, the time, just the sheer filing, the sheer court process will allow for that. The bill also says that a housing provider can file for an eviction without going through the process outlined in this bill if there are no remaining funds for rental assistance program. However, both Prince George's County and Montgomery County's rental assistance programs are currently closed to new applications. Montgomery County has stated their program will reopen, but we don't know when. And Prince George's County, when we contacted them, have not given us assurance that the program will reopen, but there is money in the program. So we just don't know how that adds, what layers that adds to this bill, because there's technically money, but they're not accepting applications. So whether it's 10 days, 14 days, 45 days, it really doesn't matter because you can't comply under the current realities of the county's assistance program. So while we're supportive of exhausting rental assistance options, AOBA has to oppose this legislation for further delaying a housing provider from filing for an eviction as an option of last resort. So thank you.
Okay, thank you very much. That's everyone who wishes to testify. So we have some questions. The first question goes to Delegate Wells.
Thank you, Mr. Chair. Thank you to the panel. So I guess the question I had, just want to clarify because those unfavorable have been stating that the landlords and management have not, that the process of them applying is something that does not exist. And so I just was wondering if you could clarify this a little further, because I know that over in the interim, we had a discussion with United Way and with many of the management companies around the coordination taking place. Some of that seemed to be largely some of the management folks helping tenants actually, get all the paperwork together. And then it seemed like there was some intimate coordination directly between United Way and the management companies. So I guess if you can kind of elaborate on that, because to me, I got the impression that a lot of what this bill is suggesting in terms of court, or in terms of saying either the tenant's applied or the landlord has applied, is already practice that's being done currently. So could someone from the unfavorable, could you talk more about that? Because I thought we were already kind of doing this a little bit.
Well, Delegate Wells, I think I can tell you a little bit firsthand about what regional management has done. Regional management, when the program opened up and said that they were ready to go with take applications, we put packets together and sent and hand delivered those to every single one of our delinquent tenants. That's essentially over almost 1,000 tenants. And this goes from the CARES Act all the way through that number goes from the CARES Act all the way through the ERAP programs that we are working with United Way and the BCAP program in Baltimore City. But once those are the blank applications, there was always a letter saying if you need help with a computer, or you need to with the internet, or you don't understand any of the questions, you can come to the rental office and get help to fill out the application. But we don't have the information. What I think I was trying to make sure that you understood is that although we're willing to help the tenants get through the applications in whatever way they want to, we do not have any of the information that is going to be needed for the program to determine whether they're eligible or not. Therefore, the tenant has to do that.
So I think just to clarify though, but just so I know, is there not a formal relationship between many of the management companies and associations and United Way, who is one of the large kind of rental assistance third-party agency in Maryland, right? Or Central Maryland, at least.
Well,
is that not something that exists? Because to me, that kind of shows that there is actual mechanism in place wherein the landlords could take on a direct role.
Well, there is a relationship between the BCAP program and United Way program and the landlord. They have assigned people to particular geographic areas, Baltimore County, Baltimore City, to assist landlords and to keep in touch with them as to what the status of those applications is. So we can, as long as we have a number for the tenants, whatever it is, identification number for the program, we can call into them or go on to one of their websites to make sure that the application is actually being worked on by the program. But that's not exactly that we don't have a contract at the front end, if you will, for working with United Way or working with BCAP. What we do ultimately have is an agreement with that program that at the end, after the tenant is deemed to be eligible and we get the funds, that we have agreed to do certain things, like the 90-day, forbearance period for going back into court in that kind of situation. But it's not a contractual situation between the landlord and the program at the beginning of the process.
Got it. Thank you. I mean, I think the key is it seemed like the relationship was moving in a good direction, and I hope that there can continue to be more direct coordination with the third party entities like a United Way and the management side. Thank you.
Okay, the following delegates have their hand up in this order: Delegate Jalisi, Delegate Holmes, Delegate Terraza. So Delegate Jalisi is next.
Thank you, Mr. Chair. So first of all, I just wanted to correct that Baltimore County DSS says they don't have any money to give out. So any property owners who signed an agreement with them will have to wait till they get the money. Secondly, again, my question that I was asking before is just for my understanding. First of all, let's clarify if this ERAP funding is for future rent or just for past rent, because I know someone mentioned that they are paying for up to 16 or 18 months of past due rent, but are they also paying for future rent? Because that's what this bill is doing, is preventing the property owner from going to court if future rent or rent in the future is not paid. So can somebody answer if what these counties are doing about future rent?
Again, if you don't mind, I'm not trying to jump on anybody else's.
Go ahead.
Thanks,
Go ahead.
But
Go
if
ahead,
I
do
could
it
talk
anyway.
about Regional's experience. Regional with the United Way, actually each program is different. The BCAP program does not seem to pay future rent,
Right.
In Baltimore City. But in Baltimore County, the United Way program would pay up to a maximum number of months, which I believe it's 16, and that can be made up of delinquent rent and up to a maximum of 3 months rent. So
Right.
if you have a tenant who's 19 months behind, they're only going to be able to get 16 months or 15 or 16 months out of the program at all. If you have a tenant who has, if on the other hand, has 6 months delinquency, and they can get that 6 months delinquency, and they can potentially, if necessary, if they need it, get 3 months ahead of time also within that total number of months limit.
I understand. Then my part of my question was also, if that happens, if a property owner accepts that money from whichever source it's coming from, they also have to sign an agreement that they cannot go to court for non-payment of rent for 90 days.
Yes, that's correct.
Right. And then, so what this bill is doing is adding another 55 days to that 90-day period. That's basically it. Right.
After the 90-day period is over, they need to get back to right.
Right. And then adding 45 days on top of it. So that's 90 plus.
Jay,
plus
hold
10
on.
plus
Let her
45.
answer. I didn't hear her answer.
Okay, go ahead. She's agreeing with me, but Mr. Chair, you can hear.
The delegate's question is correct, that you forbear for 90 days. If the tenant then at the end of that 90 days has not paid or is not paying, then you would have to begin this. My understanding of how the bill works is you would have to begin the 45-day process again, assuming that they're going to apply for rental assistance and be eligible.
And the 45 days does not include the 14-day notice period that it requires. The 45 days begin after the initial 14 days, right?
That's my understanding.
Yep. Thank you very much. Thank you, Mr. Chair.
Okay, next question goes to Delegate Holmes.
Thank you, Mr. Chair. The answer to my question should be a yes or no. The bill, in the second part of the bill, specifies that the landlord shall apply on behalf of the tenant. Can the landlord apply on behalf of the tenant? Anyone can answer. It's a simple yes or no.
No. The landlord cannot apply for the tenant or on behalf of the tenant. What we have been doing has been trying to help the tenants get the information so that they can do what they need to do to get the assistance.
Thank you very much.
Well, let me ask this question as a follow-up to Delegate Holmes's question, Kathy. If I'm a landlord and I get my tenant to fill out the paperwork, am I then able to work it for payment, or does the tenant have to do that?
You sort of faded in and out there for a second. Could you?
If I get my tenant to fill out the paperwork,
Mm-hmm.
can I then administratively apply for the assistance?
No, the tenant has to. The tenant has to essentially send that into the program. Generally speaking, it's done electronically. So a lot of times our tenants are doing that application in our offices because we have the computers and the internet connection. But they're the ones who have to make the application. We can't make the application on their behalf. They've got to sign on the dotted line. That's that they are telling them the accurate information.
Okay, next question goes to Delegate Terraza.
Thank you, Mr. Chairman. At risk of sounding repetitive here, I'm confused by this because I thought there were two programs, one where the tenants can apply for direct assistance and one where they can go to the landlords for assistance. And so, for example, in Howard County, we're told they're out of money for the direct assistance, so they need to go to their landlords to ask for the assistance. Does that not make sense to any of you guys?
So, Delegate Terraza, I will say it is a landlord, a housing provider cannot unilaterally apply on behalf of a resident because the resident still needs to self-attest and provide income eligibility information So just by themselves with no assistance and no input from a housing provider, no, I mean, from a resident housing provider cannot file for rental assistance. But there are like Prince George's County's program, for instance, they have a resident can apply by themselves or a housing provider can apply on their behalf, but it requires a fair amount of input from the resident. But that is still that's still, I don't know, 3 or 4 programs in the state. A lot of them don't let a housing provider apply at all.
Okay, so in some of the programs, and if we required it, all of the programs, the landlord could apply on behalf of the tenant.
Well, no, because there are federal regulations that require the resident to self-attest, sign on the dotted line, and provide their own income. So no, you can't cut the resident out completely because federal law requires it.
Okay, but the tenant can't can't do it without the landlord either. That set of funding.
Well, I'm sorry, Kristen, did you have?
Go ahead, Aaron.
So residents can apply, residents have applied without their housing provider ever checking in, because that's how we have so many housing providers that are unaware that a resident applied. So if every housing provider had to be included in the process, there would be no need for these bills because the housing provider would already know that the resident had applied. So no, residents can apply without a housing provider. A housing provider cannot apply without a resident.
But those are two different I'm talking about 2 different programs. The one that's supposed to be coming through the landlords and the one that's supposed to be coming directly through either the county or in Howard County, it's being done by nonprofits. Okay. All right. Maybe this isn't fair.
I think what you're speaking to is really the underlying point here is that there are so many diverse programs and procedures across county lines. Even United Way is not a uniform agreement or process. I mean, there's several different forms of agreements, even in United Way's program across county lines, and different requirements in those agreements.
Okay, thank you.
Let me try and take a stab at this. Is there in the state of Maryland any program where the landlord is able to apply on behalf of the tenant in any way?
There is not a program where a landlord is able to apply on behalf of a tenant without involvement from the tenant. Federal law requires involvement from the tenant.
Okay, Delegate Healy has a question.
Yeah, my question is about, this is very confusing. There are a lot, and different, the programs differ in their application in different parts of the state. But my question is about who gets paid. Does the money go to the tenant and then the tenant takes that money and pays the landlord, or is the money sent directly to the landlord to pay the back rent? And that's the first question.
So I think Kathy's probably the best person to answer that. I will tell you that it depends on the program.
That varies as well.
It's unfortunate that he's saying what he said. It does depend on the program, how the money gets, how the program gets the money to pay to the rental, the rental assistance payment out to, whether in our case, in the BCAP case and in the United Way programs we have participated in, it has come directly to the landlord on behalf of the tenants and applied to we apply it to their accounts. However, I do know that there are some programs out there that do give it directly to the tenant, and the tenant is then supposed to give it to the landlord. I have not experienced any of those.
Thank you very much.
There appear to be no further questions from the committee. So thank you one and all. That will conclude the public hearing on House Bill, what is it? House Bill 367. We'll proceed to House Bill 381. Delegate Solomon.
Thank you, Mr. Chair. Would it be possible actually to skip to the next bill? My panel literally just got called to the Senate, and they are just wrapping up, and we'll be back momentarily.
Sure, we'll go to Delegate Stewart, House Bill 392.
Thank you, Mr. Chair.
Excuse me, I'm sorry, I skipped over Delegate Otto by mistake. We're going to go to Delegate Otto.
Thank you, Mr. Chairman. For the record, Delegate Charles Otto, representing Somerset County. What we have before us is a salary increase for some of the county officials, the sheriff and judge of orphans courts and the county commissioners. We ask for your favorable report on this. This hadn't been done in a number of years. So with the inflation and the time commitments of some of these positions, we ask for a favorable report.
Okay. Is anybody, oh yes, Gene Atkins is signed up to testify in favor. Mr. Atkins, welcome to the committee. You have 2 minutes, sir.
Thank you. Hi, I'm Gene Atkins. I'm the finance director for Somerset County, and I'm basically just representing the county commissioners here today. And the commissioners are strongly in favor of passing House Bill 382 to change the salaries of many elected officials in our county who are only changeable by law. And there's a specific time frame where you have to go through and pass the salaries before the next term comes into play. So we are at that point in time. And the bill is necessary in order to bring all of the salaries that Delegate Otto mentioned in line with those of our peers in other counties. So with that, the county commissioners request a favorable report and final passage of House Bill 382. And I'm also here to answer any questions you might have on the numbers.
Okay, does anyone have a question for the sponsor or the witness? Delegate Healy.
Yes, just for the record, Delegate Otto, does this have the support of the delegation?
Yes. I met and we had a conversation and
are you the only person in that delegation?
Yes.
So in other words, the voices in your head all agree, right?
Yeah.
Okay. All right. It appears that there are no questions on this bill. Thank you very much, Delegate Otto and witness. Let's proceed to House Bill 392, Delegate Stewart.
Thank you, Mr. Chair. For the record, I'm Delegate Von Stewart. This is House Bill 392. The impetus for this bill was actually a lawsuit filed in Prince George's County based on some horrendous housing conditions there. And so, Mr. Chair, even though I'm not a huge PowerPoint guy and I've never used one in any bill hearing, I've got a few photos on those housing conditions to share this afternoon. I let Trish know, so I'm just going to attempt to share my screen really quickly, if that's okay.
Yes,
okay.
Go ahead.
Okay. So I hope everyone can see this. It's a little bit grotesque. So if you have a weak stomach, I would suggest you turn away. But these are just some of the photos. And actually, I picked the ones that were not as shocking to include. But these are just some of the photos. This is obviously mostly of mold in the unit. We saw some mice, which personally makes me especially queasy. And then here's just the last set of photos where you see just a huge hole in a ceiling. You see trash dumped outside. And yeah, and that's it. That's all I'll subject you guys to. But I picked like I said, I picked some of the photos that were actually some of the least disturbing, just because I didn't want to upset anyone. But basically, the deal with this bill is that Maryland state law affords renters the right to a home that meets basic structural health and safety standards. But tenants face a lot of barriers to enforcing that right. And so many Marylanders live in these putrid conditions. They're forced to inhale mold, dodge mice, and generally trudge on about their day-to-day life without structurally sound shelter or even operational appliances. Now, obviously, this is a minority. You know, I think the vast majority of landlords provide not only habitable housing, but solid housing. But we are talking about here a small number of our neighbors and our friends who live in shocking conditions. Under current law, Maryland's rent escrow provision allows a tenant to legally place rents into an escrow account when a landlord fails to make essential repairs. But filing a rent escrow action is burdensome, finding an attorney is difficult, and the remedies for rent escrow are confined to only one tenant. And so as a result, there are way more tenants living in unlivable conditions than there are tenants filing rent escrow actions. And so HB 392 fixes these problems in 2 ways. First, the bill allows groups of tenants to file a rent escrow action collectively. And second, the bill allows a single tenant to seek remedies on behalf of a group of tenants with similar issues if they opt into the lawsuit. Allowing these group lawsuits will give tenants a way to enforce their right to a safe and habitable place to live. Other options for guaranteeing safe housing just don't work. Rental housing inspection programs across the state are either underfunded or non-existent, and class actions are almost never certified. Recent Supreme Court precedent has made the commonality and typicality requirements of class certification really onerous, and smaller groups of tenants, less than about 20, necessarily fail to meet the numerosity requirement under class action certification. This bill crucially also provides for a more efficient administration of justice for both tenants and landlords alike. Forcing each tenant to file a series of piecemeal lawsuits about the same problems in the same building is a waste of time for the parties and a waste of resources for our overburdened judicial system. When tenants are indeed living in squalid conditions of the landlord's making, this bill would hasten their path toward living in dignity. And even when the facts are on the landlord's side, this bill would hasten the path to an efficient resolution for the parties and the court system. I urge a favorable report.
Okay, a number of people are signed up in favor. I also noticed that there is an interpreter for your bill. I was a little distracted when you were saying that. So when we get there, I guess I'll, well, actually the first person is Malcolm Peyton Cook. So Malcolm, welcome to the committee. You have 2 minutes.
Hi, good afternoon, everyone. My name is Malcolm Peyton Cook, and I am a senior counsel with the Lawyers Committee for Civil Rights Under Law. The Lawyers Committee is a private nonprofit, and our purpose is to secure equal justice for all through the law, targeting particularly inequities facing African Americans and other racial and ethnic minorities. I support this bill because I think that this bill supports tenant organizing for better and safer housing conditions. Prior to my time at the Lawyers Committee, I was a tenants' rights lawyer in New York City where I represented clients in proceedings similar to those proposed in this bill. These proceedings were called housing part actions, and they were an effective means by which tenants could band together and obtain better living conditions. As stated earlier, this bill would allow tenants to file cases as a group, and it's been my experience that when tenants face massive and power balances when attempting to address habitability concerns in their homes individually. This can lead to tenants being singled out for retaliation by the landlord. I've seen instances where tenants have been refused to renew leases, have had evictions filed against them, or have been harassed by their landlord in response to their trying to address their habitability concerns individually. By giving tenants a collective option, this bill reduces the likelihood of intimidation of individual tenants by giving them a way to organize and build collective power. This bill, also like the actions I was a part of in DC, will allow tenants to hold negligent landlords responsible. First, by filing as a group, they are able to exert more pressure on the landlord. Second, by permitting tenants to pursue damages against landlords that fail to make repairs, this remedy is more persuasive and provides, more impetus for the landlords to make repairs than solely lost rental income alone. Finally, the addition of a attorney's fees provision in this bill makes it more likely that tenants will be able to avail themselves of legal services as they'll be able to list attorneys whose practices depend on their ability to recoup fees.
Okay, you could begin to wrap up your testimony. The committee would appreciate it.
Yes, and just finally, I would say that, this bill will provide greater access to the courts for tenants who may not otherwise be able to. For example, if a tenant follows
you're going to have to wrap it up. I've got other.
Okay, thank you.
So I understand I have Alex Vasquez with CASA, who is going to be an interpreter for Mr. Reyes. Alex, are you with us?
Yes, we're right here.
Oh, all right, great. Take it away. I think it's Ms. Reyes then.
Yeah, Ms. Reyes, yeah.
Okay, you got 2 minutes. Then I understand you want to testify on your behalf as well, correct?
Yes, that's correct.
Okay, well, why don't we start with with Ms. Reyes, and then I'll give you 2 minutes as well.
Okay, awesome. Thank you very much.
Buenas tardes, mi nombre es Guacolda Reyes y soy residente del condado de Montgomery. También soy emigrante y viuda que depende de la seguridad social para llegar al fin de mes.
Good afternoon. My name is Wacola Reyes, and I am a Montgomery County resident. I am also an immigrant and a widow who depends on Social Security to make ends meet.
Al igual que muchos inquilinos en todo el estado de Maryland, nuestros mejores esfuerzos para hacer lo correcto e instar a nuestros arrendadores a realizar reparaciones que afectan significativamente nuestra salud, seguridad y cayeron en saco roto.
Like so many tenants across the state of Maryland, our best efforts to do the right thing and urge our landlord to make repairs that significantly impacted our health and safety fell on deaf ears.
El proceso fue aún más frustrante por la falta de respuesta y rendición de cuentas de diferentes agencias gubernamentales y códigos e inspecciones. Como resultado, nuestra asociación de inquilinos de más de 150 hogares demandó a nuestro arrendador para exigir responsabilidades.
The process was even more frustrating by the lack of response and accountability from different government agencies and code and inspections. As a result, our tenant association of over 150 households sued our landlord to demand accountability.
Desafortunadamente, todos tuvimos que presentar una solicitud individual debido a la estructura legal, que fue un proceso tedioso para muchas familias de bajos ingresos y de clase trabajadora en nuestra asociación de inquilinos.
Unfortunately, we all had to file individually due to the current law structure, which was a tedious process for many low-income and working-class families in our tenant association.
Otros no presentaron la solicitud por temor a represalias o abusos de parte de nuestros arrendadores, lo que resultó en que más del 70% de los asociados de inquilinos no presentó la solicitud.
Others did not file in fear of retaliation and abuse by our landlord, resulting in more than 70% of the tenant association failing to file.
Sin rendición de cuentas, nuestra solicitud se ha vuelto tan grave que muchos de nosotros, como yo, tuvimos que comenzar a recolectar agua de lluvia para beber, bañarnos, cocinar y limpiar.
Without accountability, our situation has become so dire to many of us, like myself, that we had to start collecting rainwater to drink, bathe, cook, and clean while the verdict of our lawsuit is currently pending.
Así que hoy estoy aquí para apoyar la ley, porque apoyando la organización de inquilinos para reparación de la situación que amenaza la vida, salud y seguridad. Es hora de responsabilizar a los propietarios negligentes y hacer justicia a los inquilinos de todo Maryland.
So I'm here today to support House Bill 0392 because it supports tenant organizing for repairs to life-threatening situations, health and safety. It's time to hold negligent landlords accountable and deliver long overdue justice to tenants across Maryland. Thank you.
Thank you for testifying. Mr. Vasquez, would you like to, you get 2 minutes if you want to.
Yes, and thank you for being patient. Good afternoon. My name is Alex Vasquez, and I'm here today on behalf of CASA, one of the largest immigrant rights organizations in the Mid-Atlantic region. I'm also here on behalf of the hundreds of tenants that have experienced firsthand the lack of accountability from landlords and legal systems that are put into place to protect them. A few months ago, CASA filed a lawsuit on behalf of dozens of families in Germantown. The case came after multiple failed events over 3 years to demand accountability from a negligent management company. Currently, it is difficult for a group of tenants to bring an action against a landlord together. Out of the 150 plus households actively involved in the tenant association, 28 families officially signed to the case. That's only about 18% of the overall tenant association. As in the case for many in the Germantown Tenant Association, the prospect of bringing an individual lawsuit raises fear of retaliation and abuse from corrupt landlords and negligent landlords. For others, the filing fee and time missed from work are infeasible and could risk their livelihoods, especially during a pandemic. The process is also challenging for older and disabled renters like Wakoda, for whom may be challenging to travel to the courthouse on multiple occasions. If the broader goal of rent escrow is to change a landlord's illegal and negligent behavior, the only way to do this is to ensure all instances of offending behavior are corrected, not just those done to the tenant filing for rent escrow. As a tenant organizer, I support House Bill 0392 because it supports tenant organizing for repairs to life-threatening situations, health, and safety. The bill also allows tenants to address building or complex-wide conditions issues in a single case. But more importantly, the bill strengthens the remedies available to tenants and ensures that tenants can hold landlords responsible for negligence and delay in a way that fully accounts for the harm they suffer. Thank you for your time, and I ask the committee to issue a favorable report on House Bill 0392.
Thank you. Next, let's turn to Carissa Hatfield. Carissa, welcome back to the committee. You've got 2 minutes.
Thank you very much, Chairman Barve and members of the committee. Once again, my name is Carissa Hatfield, and I am a staff attorney with the Homeless Persons Representation Project. One of the areas that we have primarily specialized in over our tenure as a nonprofit is subsidized tenancies and landlord-tenant operations. We support House Bill 392 as a collective action to hold landlords accountable for unsafe housing conditions, including subsidized landlords and housing authorities across the state of Maryland. In Baltimore City alone, we have experienced in the last 3 months seeing tenants from one complex, over 30 tenants filing individual rent escrow actions against their landlord for similar conditions across the entire building. A bill like House Bill 392 would allow those tenants, rather than having to each, as the 30 plus members of this group, go to court on their own rent escrow actions, instead be able to file one collective action, saving them time, allowing for judicial efficiency, among other things, and keeping this process where this landlord can be held accountable by this collective group. I know that the Housing Authority of Baltimore City has expressed some concerns with this bill, and I briefly want to address one of those concerns regarding tenants not providing adequate notice or not allowing the opportunity for repair in a collective action. Under the rent escrow law, tenants are required to give notice, and that is not going to change under House Bill 392. All of those tenants would still have been required to provide the same notice, and they would still have to allow the landlord the opportunity to repair, even if it is a collective action. So that issue is not one that should continue to be a concern and should not be affected by this bill. I would urge the committee to make a favorable report on House Bill 392, and I thank you for your time.
Thank you. Let's go next to Maurice Wilson. Maurice?
Maurice Wilson is not on the call at the moment, I believe.
Not on the call. Okay, so let's go instead to Maryland Legal Aid. Anybody from Maryland Legal Aid here?
Yeah, me, Harry Mont again.
Okay, go ahead. Harry, you got 2 minutes.
Okay.
Welcome back.
Thank you, Chairman. So again, my name is Harrison Mont. I am a staff attorney in Maryland Legal Aid in Baltimore City. Maryland Legal Aid supports this bill. We think it would do a lot to even the playing field in rent escrow. Currently, rent escrow is a tremendous burden on tenants, especially low-income tenants. They need to continue to pay their rent to the court. And while they're doing that, they still need to deal with all those costs associated with having dangerous conditions. You know, if a place is unsafe and they need to stay in a hotel, or they have doctor's fees, or even just, taking time off work, that's not compensated in rent escrow. And if you have low-income tenants, this is a tremendous burden. They might often decide to just deal with dangerous conditions. This would help in that regard by allowing multiple tenants who are experiencing the same issue to file either as a group as a group. It also provides a path to actually resolving building-wide issues. Because each rent escrow case is individual, you often have cases that are dismissed because maybe one unit passes an inspection one day. I mean, particularly issues like rats. I mean, there could be a day the inspector doesn't find any rodents, but the building's still infected. So if you wanted to, so what happens is that case gets dismissed. A week later, rats show up, tenant needs to refile. Allowing every tenant involved to file might actually allow for these issues to get resolved and not to clog up the legal system and to impose more burdens on tenants to have to keep coming to court. So for all those reasons and the reasons stated previously by my colleagues here, we encourage you to give a favorable report to this bill. Thank you.
Thank you very much. Next, let's hear from Zafar Shah. Zafar, welcome back.
Thank you, Chair Barvey and members of the committee. Public Justice Center, I'm speaking on behalf of Public Justice Center. We support this bill because we do advise many tenants on the shortcomings of rent escrow as it exists, particularly when the client is dealing with not just conditions in their own unit, but those of neighboring units which are related or make worse their own living conditions. So for complex-wide or building-wide concerns, rent escrow is simply not designed to provide an adequate remedy. It is an individuated procedure focused on the four corners of a single claim, so that the facts, the issues, and the remedies in a rent escrow case are basically limited to a single unit. And at the macro level, rent escrow has proved over time to be really underutilized. So the data in my written testimony shows that there were over the past 10 years, an average of 1,660 rent escrow actions filed per year. To put that into perspective, if you look at just the 2017 American Housing Survey data for the Baltimore metro region, including Anne Arundel, Baltimore County, Carroll, Howard, Hartford, and Queen Anne's, you're looking at 21,400 moderately inadequate rental units and 8,400 severely inadequate rental units. So there were nearly 5 times more rental properties with severe defects in one region of Maryland than there were rent escrows filed for the entire state. We have to understand why these actions are underutilized. And so one reason is they're individualized, easily making tenants fearful of targeting at their individual level. But also tenants know that the outcomes are not going to be great. They know that rarely do escrow cases result in substantial improvements. They're more likely to get short-term fixes. The Baltimore Sun's review of over 5,000 escrow cases in 2017 showed that the courts reduced rent owed in only 6% of cases and award money damages in only 1% of cases. So few renters see the utility of going it alone, taking on all the burden and all the cost. This bill provides a solution. It is focused on collective action. I want to focus on collective action because this is not a class action. A collective action, just the last point here, because this is going to come up. A class action requires that all members of the litigation be bound by a judgment unless they've opted out. And in a collective action, this is really an opt-in mechanism where tenants would be affirmatively opting in to join the litigation, but not have to take on all of the cost. So Public Justice Center asks for your favorable report on House Bill 392. Thank you.
Okay, thank you very much. We have a number of questions, and they are in the following order: Delegate Holmes, Delegate Chalisi, and Delegate Healy so far in that order. Delegate Holmes is first.
Thank you, Mr. Chair. I appreciate this. I've got a couple of questions. It seems like the language in the bill is primarily relevant to apartment style living. Is that correct, Delegate Stewart?
I maybe would refer that. I'm not sure what you're getting to, as opposed to apartment style living, as opposed to what?
Multiple dwelling units is the language in the bill.
Oh.
So it sounds as if you're attempting to target multi-dwelling units in the bill, and I'm not quite sure how this language, how the second portion of the language on property in common, of which the leased premises form a part, would apply to anything, would apply to, for example, a townhouse community. Maybe you can expand upon that if you could. And I've got a second follow-up question.
Sure. So a townhouse, by a townhouse community, you mean there are separate units, and in each townhouse you have one resident?
That is correct. And so it seems to me like you're not trying to apply this legislation to them, only to multifamily units. Is that correct?
Yeah, I mean, I think that we'd be open to some, tweaking that language to make that clear, but certainly it's our intent that, I mean, the sort of prototypical example here that we're talking about is a multifamily unit where you have shared problems across the building, because obviously, you share walls, you share common areas, you share, HVAC systems.
Sure, thank you. That's what it looks like. The second question I have is, you talk here in the bill about going after property management companies as well. And as we all know, to be a property manager in the state of Maryland, you need to do what? Go to Staples and get a business card that says you're a property manager. So I'm trying to figure out, and I don't know this because I'm not an attorney, nor do I play one on TV yet. So because you're an attorney, I'm just going to try to ask this question. If you're going after a property management company, is that going to be a personal lawsuit against the company? How do you go against the property management company if there's no real oversight of the property management company? And I'm asking only because I don't know.
Yeah, I mean, I don't think it's our intent to, I guess what lawyers would say, pierce the corporate veil. I believe I'm a retired attorney, just to be clear, but I think I remember that phrase from law school. It's not our intent that anyone would have individual personal liability. What we're trying to do in that section is to make sure that any corporation that is responsible for the conditions can be held accountable to the action. What we want, the scenario we want to avoid is a group of tenants filing against, say, a landlord, the property owner, but not the management company. And then the landlord's pointing the finger at the management company and saying, actually, they should be the ones that should have been sued. We want to provide the opportunity that multiple defendants can sort of be on that other side of the V, so that we can be efficient with the resolution of justice and not have a lot of finger pointing on the defense side.
I appreciate that. I just want you to be cautious in that sometimes property managers don't have the ability to do something that the owner of the building, in this case, wants them to do. And since they only need to go to Staples to get a business card, it makes it even more difficult, if you know what I mean. Thank you, Mr. Chair.
Okay, Delegate Jalisi is next, then Delegate Healy, then Delegate Terraza, in that order.
Thank you, Mr. Chair. So I had a question about, I think Mr. Cook was the name of the attorney who spoke, probably the first or the second one. And he mentioned that these, and just for clarity, the tenants who go this route, if this bill passes as a collective action, do they need to hire attorneys to do it? Because right now for rent escrow, there's no attorney needed by the tenant. And similarly, the part two of my question is, let's assume that everybody has attorneys, and what happens if the claim is found to be wrong, and at the end of this legal battle, the property owner is found to have done nothing wrong? Does this bill provide the legal fee for the property owner to be, or the party that prevails to pay the other side's attorney fees? That would be fair. Anyone? I can't hear you.
Does anyone have an answer for that?
I'll defer to I guess the question is to Mr. Peyton Cook. Malcolm, if you have an answer, go for it. If not, I think Zephyr is unmuted and is ready to go.
I'll let Zephyr go since he was more involved in the drafting of the.
Go ahead, Zephyr.
Yeah, the bill does not provide for landlords to recoup an award of court costs because they prevail in the action. And currently the rent escrow statute is completely silent on costs and attorney's fees, so that even when a tenant prevails, they are not awarded costs or attorney's fees.
Well, that would actually be, if they were, that would be the English rule, wouldn't it?
No, but my question was also if the tenants would be required to hire an attorney, while today they are
No.
not required to have an attorney.
They're not, it's not required. The mechanism for a tenant to be awarded attorney's cost here is for the sake of attracting counsel to take on cases that involve rent escrow.
But it does not pay for the property owner who may be wrongfully accused or dragged in. They have to pay their own fee.
If no.
What is no?
Well, Zuffer, let me see if I can clarify this. Zuffer, in America, if you sue somebody on contingency and you win, the lawyer gets some percentage of the winning. But if you sue somebody and you lose, you're not responsible for the legal costs of the defendant, are you?
No, I mean, there is fee shifting in some types of remedial case laws. And I think it's important here just to recognize that very few attorneys, whether they're low bono or pro bono, do take rent escrow cases. It is very difficult to attract counsel to take on these cases. And that's why that mechanism is included as an exception to the American rule.
Anything else, Jay?
I was just thinking that there are certain situations where the prevailing party gets to charge attorney fees, and in some tenant landlord cases, if I'm not wrong, you can even charge it as and in a lot of leases I've read, if the case is brought on by one party, whether it's the tenant or the landlord, the losing party, the winning party gets the other side to pay attorney fees. So this is not the situation in this bill. That's all I need to know.
Okay. Next question goes to Delegate Healy.
Thank you very much, Mr. Chairman. I wanted to focus on one aspect of the bill that hasn't been discussed much right now, and that's about how one person can sue on behalf of the whole group. Is that, I didn't quite understand that. I read the fiscal note. Delegate Vaughn, I appreciate this bill. I think that this is a serious problem. I'm still trying to figure out if this is the solution to it. So if you could.
Yeah, I appreciate that question. I'll give it my best shot. And I think that Zephyr was sort of in the midst of talking about collective actions and the differences there between collective actions and class actions when he ran out of time. So I may defer to him as well. But very briefly, the idea is to essentially create an opt-in collective action where a named plaintiff could be representing a group that's not necessarily named in the lawsuit, but who have opted in that they want to participate. So they would not have to go out and file a claim themselves. They would not have to get their own separate attorney, but they would be listed as parties to the lawsuit and could be bound. And this has two essentially benefits. One is it solves this collective action problem where it's difficult to have people file separately, which we've talked a lot about. And then secondly, it also provides for a more efficient administration of justice, because rather than having piecemeal lawsuits where 4 different people hire 4 separate attorneys to sue the same defendant about the same building and the same problems, clogging up the court system, it's much more efficient to have this sort of collective action mechanism to help remedy the problem that class actions are essentially not available to these groups for reasons that I mentioned in my opening testimony. But Zephyr, how did I do? I probably like maybe a C+ at best with that. Zephyr, can you clean that up for me?
I gave you at least a 90.
Okay, I'll take that.
Yeah.
Okay. Well, let me ask the next question, if you don't mind. Delegate Vaughn.
Yeah.
Stewart. Delegate Vaughn Stewart. I keep calling you Delegate.
It's okay. Call me whatever you want, Delegate Healy.
Delegate Stewart, one of the problems that I've seen over the years in these kind of situations is the tenants are often in a situation where if they push too hard and they get an inspection that says that they're living in uninhabitable place where unfit for human habitation, they become homeless instantly, and they don't have, even if they shut down the building to do all the repairs, and they put all the tenants out on the street while they do that. And And that's another reason why people are hesitant to even go this route. So have you thought about that? And is there anything in this bill that addresses that?
Yeah, that's a very interesting point. I think also what you're talking about too is that in a lot of counties, including I think your county, Delegate Healy, and perhaps mine too, the inspection regimes are oftentimes complaint driven. So there aren't regular inspections of units, but if a tenant says, hey, come inspect my unit, there are problems, then the county will come out. And I know some do that. Some don't even have inspections at all, but some do that. And you're right that sometimes in order to fix, if you get a bad inspection, sometimes to fix it, you have to, the tenants have to, have temporary housing while the building undergoes these, huge maintenance costs. And it's, totally a fair point. I guess what I would say is, number one, because the complaint process is also individualized, what we see is a lot of folks are fearful about complaining in the first place. And number two, while obviously it's very inconvenient for folks to have to find temporary housing while these repairs are made, I would rather live in a world where buildings are repaired and there's a permanent solution so that every Marylander can live in dignity, even if there are some problems with the administration of that, than the status quo, which is that we essentially as lawmakers are allowing thousands of our neighbors to live in the kinds of conditions that I showed you the photos of. Zephyr, am I leaving anything out there either?
No, I think that's great.
Okay, all right.
Okay, so there's nothing in the bill that directly addresses that.
No, but it's a great point, Delegate Healy, and like maybe if this does go to subcommittee or whatever, I would definitely be open to sort of getting together with some of the advocates on both sides, some of the stakeholders on both sides, to see if we can come up with an elegant solution to that problem, because it's a legitimate one.
Thank you very much.
Okay, next question goes to Delegate Terraza.
Okay, thank you, Mr. Chairman. Delegate Stewart, I just wanted to see if you could just really briefly expand on the conversation you were having with my amazing subcommittee chairman, Delegate Holmes, about the multiple dwellings. I was a little confused by that conversation. So why wouldn't you want to have other multiple dwelling units? Or I guess I was a little confused by that conversation.
Yeah, I guess my only point was that when we're thinking about the bill generally, we're thinking about multifamily housing of whatever variety, because that's going to be situations where you have similarities among tenants who are going to want to sue collectively. If you have rental housing of separate single family homes, for example, it's just less likely you're going to have that commonality of problems. That was my only point, that that the multifamily scenario is the one that we have in mind. Okay,
but like the townhouse, like if you have a whole bunch of townhouses, or I forget what they call them, 1/1 or 2, like where they're one in front and one in back.
Yeah,
those could be all sort of intertwined in a way that.
Sure. Yeah. I mean, certainly if you have a series of row houses, there are rentals, right? Or you have things that are not the traditional 5-story, 12-story apartment complex, but you have, anytime you have housing where you share walls and you share HVAC, you share, I mean, any sort of shared space whatsoever, even a wall touching can mean a shared vermin situation, for example. So I would consider, I mean, that's still a multifamily dwelling for the purposes of the bill. What we're saying is, in any housing where tenants could possibly have common problems, it makes sense to create a common solution.
Where they have a common landlord, I guess is the.
Yeah, where they have a common, where there's a common landlord.
Okay, thank you.
Thank you.
Okay, there appear to be no further questions. Let's turn to the, well, wait a minute. Before I turn to the opponents, did Maurice Wilson ever show up? No? Okay, let's go to the opponents. Catherine Howard is first. Catherine, you're up, 2 minutes.
Great. Thank you very much. Well, I wanted to sort of address some of the issues that have been brought up here today. One of the first things that I think we really need to focus on is the concept of the rent escrow statute is to get landlords to make repairs in a particular tenant's unit. And there is nothing in the Maryland rules of civil procedure that says that can't ultimately, if there is a multiple unit issue in a building, become a class action. In fact, in Maryland, class actions are only only allowable for plaintiffs, not for defendants, but for plaintiffs. And that's why I'm very concerned about this concept in this bill of what's known as what's being called a collective action. There are no rules that I know of and I just took out my rule book to double check. There are no rules that apply in Maryland to a collective action like there are for class actions that govern how the courts are supposed to deal with this kind of multiple plaintiff suit. Another point that I want to make sure that gets heard here is that we're talking about the fear of retaliation on the part of an individual tenant who brings a rent escrow action. There's a retaliatory eviction statute in most local laws and definitely at the state level that if a landlord is going to tries to retaliate against a tenant, they are going to get a lot of attention from lawyers who are going to take that case and apply the retaliatory eviction or retaliatory action against the landlord. That is absolutely not allowed, and that is something that we have addressed in Maryland already. I think that I do have written testimony that I think explains a good deal about class actions and the fact that we're very concerned about this bill and how it essentially is trying to do, in my opinion, trying to do an end run around the class action concept, which is already recognized in Maryland. And I think that it's very concerning to me that we're trying to do this when what the object of the rent escrow action is to make sure that individual tenant.
Kathy, if you can start to wind it up, your 2 minutes.
I'm done. Thank you.
Okay. Next, let's go to Aaron Greenfield. Aaron, welcome. You have 2 minutes.
Thank you, Mr. Chairman, members of the committee. Aaron Greenfield on behalf of Maryland Multi-Housing Association. We come in opposition to House Bill 392. You have our written testimony. The residents who are living in the uninhabitable conditions shown by Delegate Stewart are already able to pursue a class action under Court Rule 2-231. This bill, as Ms. Howard indicated, seeks to subvert those prerequisites required under the rule, and the court can certify persons as a class, placing this specific to the rent escrow statute or under the rent escrow statute is problematic. Rent escrow, as Ms. Howard indicated, is for specific individualized issues, which may not be the case in situations similar to what Delegate Stewart highlighted. And I was going to mention, again, Ms. Howard mentioned, there's already a retaliatory action statute in law that holds a landlord liable for 3 times the monthly rent in the event that a landlord was a bad actor and did those things. For those reasons, we request an unfavorable report.
Okay, questions? Delegate Terraza has a question.
Thank you, Mr. Chairman. So do any of you guys, you both talked about class action suits. Do you know of any housing defect related classes that were actually certified in Maryland?
I do not recollect hearing that. I would be very happy to look it up and do a little research. Delegate Terraza, to answer that question, don't have it off the top of my head. I certainly am happy to look it up and get back to you.
But I do know, Delegate, there are efforts, and we'll get you the list of in fact, the Westminster case people are familiar with. There are efforts to certify the plaintiffs as a class in that instance.
No, but any that have actually been certified.
Yeah, we'll get you that information.
Okay, but you don't know of any that have been actually certified.
I don't know offhand, no.
But you don't know of any. You don't know if they're
right. They don't know. They don't know of any. Well, if they can find some, they'll get it to the committee. Delegate Learman.
Thanks. I actually want to follow up on that.
I'm sorry,
because-
hold on a second. Jen, I'm sorry, did I cut you off? Did you have another question?
Not yet, no.
Okay, go ahead, Brooke.
Sure. I just want to follow up on what Delegate Carissa asked, because I think that this line of questioning is really important. Class actions are a very specific, only apply to very specific and a very narrow set of claims in the American legal system. They don't work for the vast majority of cases because you have to meet a number of really stringent rules set by the court system, including on numerosity. So, collective actions, which I have brought, collective actions make a lot of sense when there's just a small group of people, because, if you have a group of 7, to 10 people who want to sue, the court likely isn't going to certify you as a class. And so a collective action is a much simpler way to go. Certainly, I would think, and Aaron and Kathy, correct me if I'm wrong, that a landlord would rather defend against one lawsuit brought as a collective action by 7 tenants than 7 individual lawsuits. But I just don't understand, why the problem with collective actions when class actions are such a challenging to bring, set up by the court system. So why are you so why are collective actions so terrifying as opposed to having class actions?
Well, I can actually, I'll be happy to answer that. They're not terrifying. And that's not the point. I'm not terrified of having, if you will, collective action. But I think that what the real problem here is that there are things that are set in the balance of the rent escrow statute that I am concerned would get lost in a collective action. For instance, one of the things that is a defense. There's a defense that the landlord has in these repair cases. Where someone who is either a guest or a family member or the tenant themselves has actually caused the problem that is going on in the unit. That can also, perhaps happen when you have a person who is causing the problem that may affect more than just one unit. But the defense that belongs to the landlord is to talk about that particular defendant who has brought that tenant who has brought this situation essentially on themselves. And I'm afraid that if you have multiple tenants in a collective action, that those defenses are really going to get lost in the shuffle because they are very individualized and would not necessarily accrue or be something that would be uniform to the rest of the collective group. So that's just one thing that is a concern of mine.
I appreciate that. I guess as somebody who has brought collective actions, I will say, I think this is not sort of something that's known, but it's much more efficient for defendants to be defending against a collective action than 7 individual actions. So what you're saying right now, the burden is still on the plaintiff, and all 7 members of that collective action. So carrying what you're saying would say, okay, well, we would rather have 7 individuals bring their own lawsuits and each have to show that they weren't, that the building manager was responsible for not repairing this rather than it being the fault of the tenant. You still have to prove that in a collective action, but you're taking up less time for the court and for the defendants because it's all being litigated through one process and one court case rather than 7 different cases. So I understand what you're saying, but that has nothing to do with you still have to go through all that process and the burden of proof doesn't shift. It's still there. So I just don't think that that's a valid argument for opposing this. Yeah.
Well, I certainly understand your point of view on that. The other thing that I think is very important to not lose sight of in this collective action concept is that particularly in Baltimore City, The rent escrow docket is very driven by the need for inspections done by the DHCD housing inspectors, and that is going to be, that also a composite or a group of that's an amalgam of all sorts of problems is going to be something that inspector is going to have to take it in hand and be able to work with. And that, I think, that is going to be a potential complication as well. I think that it's not as simplified as either you or I would like to think it is, to have a group moving forward in the court system trying to get redress of repair issues. And I think that this is not necessarily what was contemplated by the rent escrow statute.
Can I ask one final question, Mr. Chair? Sorry.
Sure.
It's just a further clarifying, I think, the difference between class action and collective action, and why a collective action actually makes more sense in some of these cases, which is that, how, in your view, I guess, how would a court certify a class if tenants have common defects, but variable damages, right? I mean, when there's a class action, it's difficult to pay variable damages, but with a collective action, each individual has to prove their damages, and it goes through a process. So, I mean, again, how do you envision a class action actually making this work?
Well, I think that brings up a very important and salient point here, and that is that the object, we're sort of, whether we're talking about class action or collective action, we're getting away from what is the issue that rent escrow was brought to the law to do, and that is to get repairs made, as well as to give the tenant some credit, if you will, against their rent for whatever problem there was that made them not have 100% of their unit available to them at all times. And that, I mean, so when we're starting to go down the path of damages, paying damages to tenants under the rent escrow statute, I think we're getting very far afield of where and what the rent escrow statute is really designed to do, which again is another point that I'm concerned about when we talk about collective action and class actions, if you will.
I'd be happy to talk to the committee further about collective actions anytime, but thank you, Kathy.
Kathy, I've got a question. What were you referring to when you said damages?
There seems to be this, people are talking about the tenants getting damages under the rent escrow statute. There's a variety of different things under the rent escrow statute that a tenant can ask for, but the main thing that the object is to get the repairs made. There's a case called the Williams case in Baltimore that came out of Baltimore City that essentially said, well, if there was a repair that needed to be made and it did affect the tenant's use and enjoyment of the property, that there should be a weighing of how much disuse they were able to have of their property, and the rent that they put in escrow should be divided up between them and the landlord based on how much disuse or lack of quiet enjoyment that they had. That's what I was really referring to when it comes to damages.
So you're really worried about punitive damages?
Yes, I think everybody has to worry about that when you start talking about collective action.
Well, not if the bill doesn't say that, but so the burden of proof hasn't changed. The tenants have to be able to prove that. Well, how does this work? Let's say that my washing machine stops working and my landlord doesn't do anything to replace it. So under the current law, I walk over to the Rockville courthouse and apply to put my rent in escrow, right?
Right.
Okay. And then when it gets before the judge, let's say for the sake of argument that the management, that the owner of our building doesn't do anything, is the burden of proof on me as the tenant?
The burden of proof is on you to prove that the landlord hasn't done what he, that he supplied you with the appliance, B, that you notified him that the appliance didn't work, and C, he hasn't done anything to replace that appliance.
We've seen across the nation and throughout the state of Maryland that that's your burden to carry.
Okay, so let me ask this question. Let's say for the sake of argument that my landlord is asserting that the washing machine is broken because I put a bowling ball in there as a prank and it wrecked the, where, you know, so that's the counter argument. Kumar wrecked the washing machine. Right. Who has to prove that assertion? Him or me?
I think that the defense, you know, that's the defense that the landlord has. You the tenant did something that caused the damage, it caused the appliance not to work, and that's going to be on the landlord to prove.
Okay.
Or at least to the satisfaction of the court.
So let me and so these, and I haven't read Delegate Stewart's bill, so I don't know what's in it, which is often the easiest way to do these things. No, just joking. You know what? I'm going to hold that question for. I'm going to read the bill and then I'm going to ask the next question in a few days or so. Any further questions for the opponents to the bill? Okay, that ends the public hearing on this bill. Let's turn back to Delegate Solomon. Jared, are you in the building?
I am, yes, and thank you, Mr. Chair, for your indulgence and patience with our hearing times. Thank you. Unlike Delegate Stewart and Delegate Holmes, I am not a retired lawyer, and I do not play one on TV. Appreciate the committee's indulgence in timing, and I'm here today for the record to present House Bill 381, Delegate Solomon from District 18. And what we have before you today is really what we think a common sense bill around really addressing an issue that plagues our small municipalities. So in District 18, I have the privilege of representing 9 municipalities. Most are fairly small, some of which literally house 200 to 300 households. And for those of you familiar with the local government acts, when a municipality makes any kind of a change to the charter or any amendments to their charter, those changes have to be posted publicly. And we believe that public disclosure is incredibly important. But based in current statute, those notices have to be published in a newspaper of local record or a publication of local record. Unfortunately, in Montgomery County, the only paper that we have of record is the Washington Post. And so that means that our local municipalities, again, sometimes 200 to 300 households, are required to publish that notice in the Washington Post at often pretty exorbitant rates. You're going to hear from one municipality in particular that had to pay over $2,000 for a 1-inch by 3-inch ad. And so what we've done is we've created, we think, a reasonable compromise into the law that would give municipalities the ability to essentially notify their residents either directly through the mail or by directly hand delivering. So in the instance of the small municipality you're going to hear from, literally a postcard or through their newsletter. I want to just say thank you in particular to Delegate Healy, the subcommittee chair, who has been really generous in sharing her time and some thoughts on how we move forward on this. I know this issue has been before your committee in a variety of different forms before. We've also had some really positive conversations with the Press Association, and we think, we're willing to make additional changes to the bill if needed. But I think that, again, we found a pretty reasonable middle ground here that preserves the important notification requirement and public right to know, while also trying to save money for our small municipalities who, often are operating on, very, very, very tiny budgets with next to no full-time staff. So with that, I will turn it over to my panel and appreciate the opportunity to present and would ask for a favorable report.
All right, let's next go to Andy Leon Harney. Andy, welcome to the Environment and Transportation Committee. You have 2 minutes.
Thank you very much. I'm Andy Leon Harney. I'm the village manager of Section 3 of the Village of Chevy Chase. We're a very small community, just 282 homes. We are one of 157 municipalities in the state, many of them small enough to allow for hand delivery, certainly mail delivery of charter amendment at a cost that would be far less than newspaper ads in some of the larger markets. For example, Jared already alluded to the ad that we placed that was run for 4 weeks in the classifieds, ran 1 inch by 3 inches. And as a former writer for the Washington Post, and my husband was a syndicated column for the Washington Post, nothing against the Washington Post. However, it seems an inordinate amount of money to pay when we reach our residents very well with unbiased, clear reporting of the exact wording of the same charter amendment was also not only advertised in the paper, but also in our newsletter, which is mailed to everyone, also on our website. So there's plenty of opportunity for those who are most affected to read and see and discuss any proposal, and that it doesn't really need to be in a newspaper ad in those larger markets where that would really be a burden. And I think that there's no vetting by a newspaper of these ads. There's no independent assessment. So, and I'm quite certain that charter amendments are not going to break the back of any newspaper. And I'm also quite certain that the 4 weeks of ads that we placed were probably not read by a single one of our residents because they had a newsletter delivered to their home that had exactly the same information and the context in which it was developed in front of them. So I humbly ask you to consider my testimony and vote to support these modest amendments of the existing law.
Thank you very much. Next, let's go to Justin Fiore on behalf of MML. Justin, welcome to the committee. You have 2 minutes.
Good afternoon, and thank you, Chairman Barve, Vice Chair Stein, committee members. Again, for the record, my name is Justin Fiore. I'm here on behalf of the Maryland Municipal League in support of House Bill 381. As the name suggests, the purpose of the public notice is to engage and inform the public on the business that is being conducted, to notify them so that they know how and where to share their input that local government officials need to better represent them. It's a core aspect of little d democracy, and our governments fully support it. The proposed alternative will reach every single residence and won't cost them the subscription to access. Again, every single residence for free. Newspapers have been the most effective and cost-efficient method to disseminate government information for the past few hundred years. That is increasingly not the case for municipal governments. MML has long shared that one-size-fits-all approaches don't work in Maryland, and it certainly doesn't make sense that the Chevy Chase Villages and others should have to pay $2,000 to advertise a charter amendment in the Washington Post. I understand there are additional values to having a newspaper report on government actions, and our members have always been open to a requirement that a copy be shared with the newspaper general circulation. But as far as engaging and informing the public goes, this alternative process does a better job than any newspaper advertisement, and it won't cost tiny governments large sums to achieve. We ask for a favorable report and thank you for your time.
Thank you. And finally, the awesome mayor of the city of Rockville, Mayor Bridget Newton. Bridget, welcome to the Environment and Transportation Committee.
Thank you, Chair. Thank you, Chair Barve. Can you hear me?
Yes,
Great.
I can hear you.
Thank you. Thank you for this opportunity. As you mentioned, I'm Mayor of the City of Rockville, and I'm here to testify in strong support for HB 381. We are grateful to Delegate Solomon for sponsoring this important legislation. The Rockville Mayor and City Council strongly support this legislation as it will provide needed relief for us and other municipalities faced with the increasingly high cost to notice proposed charter amendments, public hearings on planning and zoning issues, budget, and other city business. It is unfortunate that there is no longer print media in Montgomery County except for the Post, which has been mentioned, and therefore the only option available to meet this noticing requirement is to place these legally required ads in the regional newspaper, which is quite expensive. For FY22, the city of Rockville has already spent almost $10,000 on legal noticing costs, and the small size of those ads placed in the newspaper's classified listings can be easily overlooked. HB 381 begins to address these issues by expanding charter amendment noticing options to include a summary of to include a copy of a fair summary of the proposed charter amendment delivered either by hand or mail once to every municipal residence. In the city of Rockville, as you know, Chair, we have a newsletter that comes out called Rockville Reports. Under HB 381, the requirement can also be met by including the notice in a newsletter or any other regular municipal publication. HB 381 is a welcomed improvement to a costly, antiquated, and inefficient process. The bill supports greater transparency and community engagement and would permit Rockville and other municipalities to expend more of our taxpayer resources on high-quality programs and services. For these reasons, we urge the committee to provide HB 381 with a favorable report and forward it to the full House for a vote. Thank you.
Mr. Chairman, you are muted at the moment.
It just so happens before I have a copy of the Rockville reports right here. Imagine that. Okay, so the first question goes to Delegate Foley, then Clark, then Healy, in that order.
Thank you, Mr. Chair. Well, in the interest of full disclosure, I am the retired national president of the News Guild, which represents newspaper workers, or continues to represent newspaper workers, even though I'm not there. So I would just like to, first of all, comment that I think there are a lot of good reasons for a newspaper or a news outlet of general circulation to have these notices put in. And I do appreciate that small communities have, that it's a budgetary item and that there are costs associated with it. But this assumes that only people in the community are interested in what's in the charter amendment. And I think that the reason to have a general circulation is to have it generally circulated more widely. So that's one thing. The other thing is that it also prompts news coverage by putting it in a publication of general circulation. So it's an issue of transparency. However, having said all that, my question is, it says in here, any other regular municipal publication. And so I would I know there was an example of the Rockville publication, right? But what other kinds of regular municipal publications does this contemplate? Maybe that's for Jared or for Delegate Solomon to answer.
Yeah, Delegate Foley. I mean, so that was language, frankly, that the council suggested to sort of cover the newsletter. They may not, each individual municipality may not refer to it as a newsletter. And to your point, I mean, you'll hear from Rebecca Snyder from the Press Association. We've been having conversations. Nobody is opposed to notification requirement, and I think maybe even Justin had mentioned it. We're willing to put something in that says every municipality has to notify these notices have to go to papers, or they have to go to the Press Association. We've been having this conversation because they aggregate those notices. I would just venture to say, I've been a longtime subscriber to the Post, and obviously that's what we're discussing here because that is the only paper we have in Montgomery County. I would not have been able to tell you where those notices were. I don't get the physical paper anymore. And again, between the Post and the Sun and other publications, I think my wife and I subscribe to probably 3 or 4 newspapers. And I would not be able to tell you where, again, those ads were posted in the Post. And so, again, I think we were trying to with this, obviously this wouldn't apply, not every municipality in the state is going to take advantage of this. For places where the ads are significantly less expensive, where the burden of getting a notice to every member of the municipality may be too great, the newspaper is going to be a great tool for that. And frankly, I think most of us in Montgomery County wish we had more local news. That probably would mean this bill wouldn't be needed. But the post is, again, in the current construct of the law as we have it now, the post is the only publication of record that satisfies the requirement for this.
Okay, thank you. If I just could make one more comment. Part of the reason we only have the post is because a lot of the classified advertising, which is what this is, which is where it goes, not necessarily this legal advertising or these notices, but classified advertising in general has dried up, and so have the newspapers. And that's my only point, is that, it is a revenue source for sure. But I do appreciate it. Thank you, Delegate Solomon, and thank you for answering my questions.
Okay, next question goes to Delegate Clark.
Thank you, Mr. Chairman. And this is for Delegate Solomon. Delegate, this is just written for municipalities. This wouldn't be written that way. It could include counties.
Correct. Yeah, this would just be for municipalities.
One of the reasons I asked that question, for quite a few years, my county, Calvert County, which is a small county, 93,000 people, have tried to eliminate having to advertise in the local papers. And it's been a real burden since a lot of them have closed, and, we're down to maybe one or one and a half every other week, and just go to online advertising for that. Wouldn't you say that this bill could actually do some good for small counties? I mean, I'm not sure what the population of the city of Rockville is, but I bet it didn't. If it's smaller than 93,000, I'd be surprised.
No, I think we're at 70, aren't we, Madam Mayor?
70, yeah.
Yes, Chair.
And we're at about 93,000 people spread out in a pretty large peninsula. But I'd be very interested to see how this bill goes, because I think that the smaller counties could probably follow through with that to save themselves some money also.
Yeah, although that wasn't a question, if we were to include,
isn't that so?
Yeah, well, if we were to include counties, we'd have to include all of them, I believe. So
yeah, that could be a bill for next year or something like that.
Yeah, maybe.
Yeah.
Delegate Healy. Delegate Healy.
Yes, I just was unmuting myself. Took me a second. I've also fully disclosed that in my previous career, I was the editor of 2 local county newspapers in Prince George's County, and so I know that this kind of revenue source. Really, those publications, one of them is gone totally now. The other one exists mainly because of public notices like this. I mean, they're probably their main income. So my question, but the other side of the equation is also about the publication and the independent publication of these documents, these public notices about things. So my question is, how do you maintain the independence of this kind of publication if the government produces the notice and delivers it and is responsible for storing it for future reference? And there's where's the independence that makes sure that this isn't open to not only lack of transparency, but also shenanigans?
Thank you, Delegate Healy. And actually, I also just wanted to touch on Delegate Clark's comments. We're actually not, I understand where you're coming from on that, Delegate Clark, but I think we're cognizant of not wanting to sort of bridge the digital divide issue as well. So I would leave the conversation on sort of a larger context of the committee. And I think even as Mayor Newton said, this is more of sort of a supporting things for smaller municipalities. Not everything in here obviously is going to be applicable to the city of Rockville based on their size. And Delegate Healy, I think you've raised a good point. And again, in the conversations that we've had with the Press Association and as as Justin mentioned from MML, I think we'd be more than happy to put some sort of a notification requirement that these have to go to papers of record. That if the Press Association is willing to sort of continue to aggregate these notices, that there is some requirement that it's sent to the Press Association to be posted. I would just say there is no. I mean, and maybe Andy can comment on this more. I don't believe that there's any editorial oversight of the classified ad, that, you know, the Section 3 could put essentially whatever they wanted in the classified ad. And I don't know that there would be any reporting or, you know, again, journalistic oversight of what goes into those classified ads versus, you know, maybe that same text or text going into the newsletter. And the other thing I would say in response to that is, again, I feel like, you know, in the examples that we're talking about here in these small municipalities, more people are likely to see it if it is sent directly to them in one form or another, where frankly, I think those folks would probably raise any ire or concerns over what they saw than, you know, potentially a small ad in a paper that most people, certainly in the context of the Post, you know, would not see.
As you may know, I also served in local government. I was on the city council in Hyattsville before I was in the legislature as well. And so I see this from both sides of the issue. But I wanted to ask about the one, a lot of these notices require that they be published, not only be published in a newspaper of general circulation, but also appear 3 times so that people will have a chance if they're away on vacation or whatever. A lot of these newsletters, these town newsletters, come out once a month, once every 2 weeks, once every 2 months. And if you miss that particular notice because it didn't come in the mail or whatever reason, you'll miss it entirely. And the question is about the summary that you put in. Why would you put a summary and not put the full ad? I mean, these ads are like, like 2 inches long.
Yeah, well, so Delegate Haley, the language that we have in the bill is the same as it is in current law. The current law says a general summary as published in a paper. So we would assume the general summary would be the same because the current law only requires that the full text of the amendment is posted publicly on the actual building, but it doesn't require that the full text is posted in the paper.
What building are you talking about? This is about charter amendments, right?
Correct. Yeah. So current law says that charter amendments not only have to be published in a newspaper of general circulation, but they physically actually have to be posted on either the town hall or whatever passes for the town hall. So I think it's on the first or second page of the bill. I had it just in front of me.
That's okay. I'll take
the language.
Thank you for that, and I'll look forward to talking to you further on this. Thank you.
Yeah. Thank you for your support and help.
Okay, there appear to be no further questions. So, well, I'm just going to come right out, Delegate Solomon, and ask this. I mean, the entire point of this is so that people who don't live in the jurisdiction hear about this. When I was a resident of the city of Gaithersburg, I didn't really care what the city of Rockville would have been doing, maybe, or what Charles County is doing, or, but theoretically, at least, I have the access to, I would have had the opportunity to find out in some fashion. I mean, what is the workaround for that? I mean, I don't buy that only the people who live in the jurisdiction are entitled to have this information. What workaround do you have to get around that to inform the broader public?
Yeah, I mean, so, we could, again, as we've mentioned, we've had conversations with the Press Association. They serve an aggregation function where they take all of these notices that are posted in papers and then post them actually on their site. I think there's a way that we could, continue to notice newspapers and publications that these are there without necessarily having the advertisement requirement. In the conversation in the Senate hearing, there was talk about, maybe creating some sort of a sliding scale based on municipal size. So I think there are some options, and we're happy to look at them. This was the way this was drafted is the way that we thought, we could get at a problem for some of our municipalities, and I think increase the notice of residents so that they're able to to understand and engage better with their local government as well.
Okay. All right, let's turn to the person who signed up in opposition, Rebecca Snyder with the Maryland, D.C. Press Association. Rebecca, welcome to the committee. You have 2 minutes.
Thank you, committee, and thank you for the opportunity to testify. For the record, my name is Rebecca Snyder. I'm the executive director of the Maryland, Delaware, DC Press Association. And I feel like a lot of the very cogent questions that came up during testimony really are things the committee may want to consider. You know, public notice, if you look at it as a best practice, should be independent of the entity that it is directed upon. It should be archivable, verifiable, and reach the widest possible audience. We believe that more notice is better notice. I certainly wouldn't sit here and say don't hand deliver all sorts of things to the residents of your municipality, but it's a broader issue than that. You know, you want to inform the wider community. And there's been some discussion about what kind of oversight publications have over notices. And so their job is really to make sure that it's running correctly when it should, and to provide that verifiable and archivable independent publication. So it's true, you know, we're not going back and saying, this charter amendment seems suspect. We're making sure it reaches the widest possible audience. This is a statewide bill, so although it's directed particularly to solve the issues of municipalities in Montgomery County, which I'm sympathetic to, it would be in effect statewide. We are in conversation with the delegate. I appreciate those conversations. I'm hoping we can work something out. But when we think about this, these are big deal issues. Charter amendments, they are things that materially affect residents, and residents have a right to know what's going on in their communities and their government. So as it stands, we urge an unfavorable report, but of course, we're always open to discussion. And I know I'm nearly out of time, but this mystical site that everyone keeps referencing that we aggregate is mddcnews.com/public-notice. Notices with an S on the end. Thank you.
I have a number of questions, and I can't believe that I'm finding myself asking this question, but it's not so far-fetched. What would happen if Jeff Bezos got tired of subsidizing the Washington Post and he let it go bankrupt? What would become the newspaper of public record if we had no newspapers?
So, number one, the Post is profitable, so I don't think anybody's going to be looking at that. Number two, there are other publications. So I know there's not, the Gazette's really hit us all hard. However, the closure of the Gazette's hit us hard. The Daily Record actually publishes some notices in Montgomery County, so that could potentially be an option. The Baltimore Sun also publishes some notices for Montgomery County. Now, I don't deal in the day-to-day businesses of our members. I'm here really to recognize sort of the philosophical good government practices around public notice. But there will always be some sort of publication or entity. Maryland is very lucky right now, and I'm not going to say this is the case nationally, but there is a print publication in every jurisdiction that is an appropriate paper of record.
Well, I don't think it's far-fetched anymore to imagine a world without newspapers, because I think we're headed there. By the way, I've been looking on my Washington Post app during this public hearing, and I haven't found any public notices in it. And I haven't gotten the paper version of the newspaper, and I don't even know how long. I mean, what value is a public notice requirement if you can't find it on your app?
And I can't speak to the app, but I will send you the link to their notice site. I mean, all of our members upload their notices to our aggregated site, and the Post has a pretty robust function for that. I can tell you that I get calls so often from people saying, I have a notice. I have a notice that is that I need you to take down because, it says that I had this instance, or whatever the case might be. People they come up in searches. They are there.
Well, I mean,
print.
I put the word notices in my Washington Post app, and I haven't gotten anything at all. I mean, I find that curious because somebody paid them to put notices up in their paper, and it's the closest I get to a non-news article is cookie notice by Washington Post staff.
And now you have me feverishly looking myself. So I will follow up with you on that.
Okay.
I can say though, this is a statewide bill. So it shouldn't be about one paper. I know there's a lot of concern or discussion about rates from the Post or how the Post is doing this, but this is not about the Post alone. And so I would caution us not to paint caution the committee not to paint such a wide brush on this particular issue because you can't particularly find it in the Post. I will happily send you the link and where it is on the app.
Okay. And then finally, if the purpose is public notification, why isn't it good enough for the city of Rockville, say, to have a glass case outside of town hall where anybody can walk up and check that out? I mean, let me make the argument for that as a method of public notification. If you're really interested in if you don't live in Rockville and you're really interested in what Rockville is doing, if you want to make sure they're not about to annex your community, for example, or something like that, wouldn't that be a more effective way to communicate to the public?
Except then you have to walk by wherever that's posted every day. You have no idea when that posting is going to occur or how it's going to be. That's one of the main problems of like this idea of, aside from the independence issue, which is a big issue, just the idea that you would have to go to so many different places to keep track of the things that you might be interested in. You'd have to go to all the different municipality websites every day to see what they're posting, as opposed to finding it in one place in your local newspaper or your local. When you said earlier that newspapers may be no more, I want to be very clear that news media is still here. There are wider audiences for news media than there ever have been. They're a mix between print and online, and that is the way we present notices as well. So you're talking about fracturing that media the landscape of finding out what's going on in your community in a variety of ways. And the idea that, especially in these times, we're going to like every day walk to the town center to see if someone's posted something, that is, I think, unrealistic.
Well, I mean, does anything truly disappear in this day and age? If I say something embarrassing right now, it's going to be on the web forever. I mean, that's where we are right now. I don't know. I just don't think that documents, I don't think it is true to say that documents can't be publicly disseminated in an encrypted fashion that would require the use of the paid media.
Well, I think you also have to look at what's most sensible and realistic for where people are looking and for those placing the notices. And I could be a total bitter pill and talk about all the Swiss cheese that case search has become because of all the well-intentioned expungement bills that are out there. I mean, it is difficult now to understand, the public record in terms of the courts because expungement has wiped that record clean. Now you can make arguments that, that information lives on in other ways, but you have to do deep and wide searching in a way that makes it harder to find that needle in the haystack. And so when you use the news media, which is the way people look and search for information, and it is credible, that is where people have traditionally looked and will continue to look for this information. We just feel like that is the place where public notice belongs.
Okay, well, do send me that notice of that link because it looks like the Washington Post is trying to hide it from me on their app. So
I totally will. Thank you for that.
Yeah. Okay, any other questions for Ms. Snyder? Seeing none, I think I'm seeing none. Yeah, seeing none, that ends the public hearing on that bill, and it ends the public hearing for today. Announcements from subcommittee chairs. Anybody have an announcement? Anybody at all? Delegate
Mr.
Lehman.
Chair.
What, I'm sorry, Delegate Learman.
Thank you. So land use and ethics will not be meeting this week. Next week, I know 9 a.m. was challenging, so we're going to try to see if we can meet between session and our hearings at some point during the week next week. So just listen for announcements. Thanks.
The vice chair has an announcement.
Thank you, Mr. Chairman. The Environment Subcommittee will be meeting tomorrow after bill hearings. Thank you.
Very well then. Delegate Lehman has
Thank you. Yeah, thank you, Mr. Chairman. Natural Resources has not met yet at all, and we're in week 4, I think, of the session. Are we going to be meeting anytime soon?
We'll meet next week.
Well,
Okay.
there we go, asked and answered. Delegate Holmes.
Thank you, Mr. Chair. Housing and Real Property will be meeting tomorrow. Thank you.
Okay. DFH.
Motor Vehicle Transportation will meet on Thursday as usual. Thank you.
Okay. Anyone else? Delegate Healy.
Yeah, local government will meet on Thursday immediately following bill hearings on just 2 bills.
Okay. Delegate Clark. Jerry, you need to unmute yourself, man.
I said I'm good. I just hit the wrong button.
Okay. Anyone else have anything for the good of the order? If not, meeting is adjourned. Have a great day, everybody.
Mr. Chairman, do you want to say something about Friday?
Oh, yeah, I do want to say something about Friday. We're probably going to be voting as a committee Friday. No, actually, we're definitely going to be voting as a committee on Friday. How's that?
All those in favor?
It'll be as early as possible so that people can get out of town if you're in town, or you can go back to lounging around the house if that's what you're doing too. So there we go.
All right, thank you.
Okay.
Mr. Chairman, can I make a quick
Sure.
statement?
Yeah.
I understand we had a sighting of a second Democrat down at St. George's Island over the weekend down in St. Mary's County. And I wish I'd have knew he was going to be there, because I took him around and showed him all our beautiful Tesla charging stations
Oh, boy.
we have over on 235.
Okay. Well, you should definitely tell Delegate Fisher, Mark Fisher about that. Okay.
He doesn't come that far south. We don't allow him in there, but I hope David Fraser Doggo had a very good time in St. Mary's County last weekend.
Okay.
There was an unofficial sighting though.
Unofficial site. I don't know if it's official now, but maybe you have to buy an ad in the Washington Post to make it official.
Yeah, we can put that in the Washington Post.
Yeah, right.
It's a beautiful county.
Yeah.
Oh, yeah. All right, meeting adjourned, people. Have a good day.